Hello, 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 hello. We are going to watch a trial. I just saw it pop up, and it is literally, it is about a guy who's representing. I'm excited. Wisconsin, as we all know, Wisconsin is tons of fun. Always has something. This guy killed his neighbor. So that's what we're watching.
Thank you. You may all be seated. All right, ladies and gentlemen, before the trial begins, there are certain instructions you should have to better understand your function as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based solely upon the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not begin your deliberations and discussion of the case until all of the evidence is presented and I have instructed you on the law. Do not discuss the case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communication. Do not use any electronic devices such as mobile phones or computers, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the parties. If you come into contact with any of the parties or the witnesses, do not speak with them. For their part, the parties and the witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you think might be useful to you in understanding the issues presented. Do not investigate the case on your own or visit the scene either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about the trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on the jury. Do not use a computer, phone, or other electronic device to share any information about this case. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate it's tempting when you go home at night or even over lunch when you check in with a loved one to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this matter. After the trial is complete, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and taxpayers. You are to decide the case solely on the evidence offered and received at trial. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. And third, any facts to which the parties have agreed or stipulated, or which the court has directed you to find. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with a notepad and a pen. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. So you need to pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness and of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit their testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The parties will now make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Because the state bears the burden of proof, the state goes first in most phases of the trial. Attorney Tom Bosco, you may give your opening statement.
Thank you very much, Your Honor. Madam Court Reporter, or Madam Clerk, rather, can I please have the TVs on so I can project the PowerPoint? Thank you. Thank you very much. May it please the court, ladies and gentlemen of the jury, this is why we're all gathered here today in this courtroom, for Carlos, to figure out what happened to Carlos, because the evidence is going to show that on April 14th, 2024, this defendant, Kevin Lychwick, murdered him. He shot him twice, once in the torso and once in the center of Carlos's face. This is a picture of Carlos. This was a much better day for him than April 14th, 2024. And I think it's important before we talk about the facts of this case to give you a little bit of information about who Carlos was as an individual in life before we talk about what tragically happened to him. Carlos lived in an apartment at 1512 East North Street here in Waukesha. It's actually just a stone's throw away from this courthouse. It's just down the hill. Some of you may have even driven past this apartment complex when you came to court a little bit earlier this morning. Carlos was just 55 years old on the day that he was murdered. He had goals in life. He was planning to start his own business, and he was very, very close with his daughter, Talisa. In fact, him and Talisa enjoyed going to different restaurants together. They enjoyed going to different Mexican restaurants. They enjoyed trying chips and salsa from every single Mexican restaurant that they went to, and that's how they would determine whether a restaurant was a good one or not. The relationship between Carlos and his daughter had never been better at the time of this incident, before he was tragically taken in this case. April 14th, 2024 is the day that the evidence in this case is going to show when this homicide took place. What you're going to hear is that on that particular morning, the evidence will show that Carlos got up that morning and went to a hardware store where he made a purchase. We know this because there was surveillance footage that captured him at this particular hardware store. We also know from his bank statements that he made a purchase on April 14th, 2024. We also know that after he finished his transaction at the hardware store, he returned to his apartment. And we know this because there was an apartment manager. Her name is Glenda Rose, and you're going to hear from her very early on in this case. She'll be one of our first witnesses. She actually witnessed Carlos in the garage area of the apartment complex cutting wood, and she actually greeted him. So we know that he made it back from the hardware store to the apartment complex where he lived. Unfortunately, after Glenda saw Carlos in the garage area, Carlos was never seen alive again. And despite many family members, including Talisa, his daughter, trying to figure out where he was, nobody heard from him. Talisa actually reported him missing, okay, because it was out of character for Carlos to actually not contact his daughter. This was something that whenever Talisa called Carlos, at this point, Carlos was always very prompt in terms of getting back to her. So the fact that she had attempted to call her father and he hadn't gotten back to her, that was very suspicious. So there was a period of time in which several months, nobody knew where Carlos was. Nobody had heard from him. We were trying to find him. And October 30th, 2024 is when we made a very startling discovery. What happened on that day and what the evidence will show is that there was a gentleman named Nathan Poley. Mr. Poley is a resident at 1512 East North Street, the same apartment complex that both Carlos and Mr. Lychwick lived at the time of this murder. And Mr. Poley was also a maintenance worker at that particular complex as well. And so what Mr. Poley was doing on this particular day was he was doing some yard work in the wooded area behind this particular apartment complex. So to give you a little bit of a sense of what this complex is like, this is a 2-level complex. There's units on the ground floor, and then there's a second level, and then there's additional apartment units on the second level. And then bordered to the back of that complex is a giant hill with some woods in the back area. So Mr. Poley was in this wooded area. He was doing some yard work, and he came across this blue tarp that you see depicted in this photo. And at first, Mr. Poley didn't think anything of this blue tarp. He thought it was just something that somebody had thrown away. But as he got a little bit closer to it, he made a shocking discovery. Underneath the tarp was Carlos's remains. And the tarp was covered, you're going to hear, in sticks, branches, and other foliage, almost as if the person who had set it there did so intentionally in order to hide what was under that blue tarp. The police get called because Mr. Poley reports what he found to the apartment manager, and the police are called, and the police respond to the scene. And ultimately, Carlos is determined to be the individual whose remains were found under that tarp because dental records were able to positively identify him as such. His autopsy was performed on November 1st. There's going to be a medical examiner that's going to testify in this case for you as well. The medical examiner is going to tell you that she found trauma associated with Carlos, that she found a firearm projectile that was located attached to Carlos's scalp. There were entrance and exit wounds, and that there was a second projectile that was found under Carlos's torso area as well, and that he had an injury to his lower vertebrae that was consistent with a gunshot wound as well. Given the length of time that Carlos was missing from April to October, his body was in a very severely decomposed state. And unfortunately, we'll have to show you some pictures of that, but that's what happened in this case as well. So now we have this homicide. We have this body in the woods, and the Waukesha police are now involved, and they're investigating this. And they're at a disadvantage, is what you're going to hear, because of the length of time between when Carlos disappears and when he's ultimately discovered. So the police are really behind the 8 ball here. They have to hustle to really uncover evidence and follow leads and make sure that they're identifying the person who's responsible for this. They start to investigate. They interview several people at the apartment complex. They canvass the area. And to be frank with you, for a while there, wasn't looking very good. They were having some difficulty figuring out who did this, what were the circumstances surrounding this. They knew it was a homicide, but they didn't know who actually was responsible for this. And then what you're going to hear is they caught a huge break. And the break came in the form of a gentleman named Anthony Lefebvre. And for the court reporter, that's spelled Lefebvre. Anthony, you're going to hear, was a resident at this particular apartment complex as well. And Anthony had a trail camera. And Anthony had been given permission by the apartment complex to build a garden in the wooded hill area behind the complex. And in order to keep tabs on this garden that he was building and to show the progress with family members, Anthony also set up a trail camera with the apartment complex's permission. And the footage on the camera dated all the way back to April 29th, 2024. So just a couple of weeks after Carlos went missing, and the evidence will show he was murdered on that particular day. The police came out and they saw the trail camera. And then they said, hey, we'd like to take a look at that footage just to see if there's anybody on that camera. And Anthony was very cooperative. He gave the police the footage, as you're going to hear, and the investigators reviewed it. And what they found on that trail camera was the defendant, Mr. Lychwick, walking around the area where Carlos's remains were found at very odd hours of the night. They saw the defendant carrying a white trash bag. They saw him suspiciously looking in windows of the apartment complex as if he was looking to see if somebody was watching what he was doing. He was seen in one clip, and you're going to see this as well as part of the state's presentation of evidence. He was wearing boots. At one point, he was kicking an item off his boots after he was seen walking in the area where Carlos's body was ultimately discovered. And he also was carrying some sort of tool. We don't exactly know what tool it was because of the quality of the video footage, but he's definitely carrying a tool as well. So the police now start to look into Mr. Lychwick because, you know, this is suspicious, right? And we're trying to see if this is the individual who's responsible for murdering Carlos. And once they start to look into Mr. Lychwick, they make many shocking and incriminating discoveries based on the evidence. So what Detective Stern and I did last week in preparation for this case is we sat down and we highlighted together, we came up with a list of what we think are going to be the most compelling pieces of evidence that you're going to hear. It's not all the evidence that you're going to hear in this case, but this is what we believe are the most compelling pieces of evidence that you're going to hear that point towards Mr. Lychwick's guilt in this case. First piece of evidence that the police found in this case was a note. The police went and got a warrant. They got a search warrant to search Mr. Lychwick's apartment to either confirm or dispel their suspicions that he may have been involved in this homicide. What they found, and you'll hear more about this during the state's presentation of testimony, was several documents that were handwritten with several quote-unquote operations listed on them. One of these pieces of paper, and you see it depicted here on this photo as well, contained information about an operation named Operation Slop Shop. You'll see it at the top of this exhibit as well. Specifically, as it relates to Operation Slop Shop, the piece of paper that was found in the defendant's apartment, where, by the way, he lives alone, he does not have a roommate, specifically names Carlos as a, quote, threat. There was an additional piece of paper as well describing another operation. This particular piece of paper indicated that Operation Slop Shop had been completed and that the threats from that first stop had been, quote, neutralized. There were additional pieces of paper as well found in the defendant, Mr. Lychwick's apartment as well. There were several other operations listed with many other individuals. The important piece is that those individuals you're going to hear had connections to Mr. Lychwick. So if the idea is that he didn't write the note, well, you're going to hear that several of the individuals listed on these notes, again, were connected to him. And then when the police were serving the warrant on Mr. Lychwick, at Mr. Lychwick's apartment as well, you don't always get Perry Mason moments, you know, in the middle of trial. But this case, we actually have one of them. Because when the police were serving the warrant, Mr. Lychwick was given a copy of the search warrant for his particular apartment, a courtesy copy, if you will. What we do in Waukesha County is we try not to include victims' names in court documents because they have a right to privacy. We want to make sure that we're not unknowingly exposing their name or their information to the public for their own protection. So the search warrant that was given to Mr. Lychwick only said victim A. That's all it said, victim A. Yet, you're going to hear that when Mr. Lychwick was given a copy of that warrant and he looked at it, he exclaimed, quote, Carlos Maldonado, I had nothing to do with that. At that point, we had not made public the fact that Mr. Maldonado's body was the individual that we had located on the grounds of 1512 East North Street. The evidence is going to show that only the killer would have known that Mr. Maldonado was the individual who was on that grounds when Mr. Lychwick made that statement. Another compelling piece of information that we found in this case was a storage unit. Now, during this investigation, the police looked into a bunch of different things as it relates to the defendant. We looked at his purchase history. We looked at how he was spending his money to see if there was anything that was suspicious as well from an investigative standpoint. Mr. Lychwick was on a pretty tight budget. This is what we found from looking at his banking records. He was living on SSI. Yet, the evidence is going to show that on November 1st, 2024, just 3 days after we discovered Carlos's remains at the apartment complex. Remember, he was found on October 30th. So just 3 days later, what we found is that the defendant drove all the way up to the Fox Cities area. He drove to the Kimberly area, and he took advantage of a 1-month free promotion to rent a storage unit in Kimberly, Wisconsin. We know that on November 1st, from what we found in his phone, that he was spending hours searching for storage units here in Waukesha County. We know, as I stated, he was on a tight budget. He was budgeting about $50 for gas. This trip, round trip to go from Kimberly back to Waukesha County would have greatly blown through his gas budget. Yet, okay, we know that he went all the way to Kimberly, and you're going to hear from the representatives from the U-Haul as well, and he rented that storage unit.
I wasn't going to do a live.
But he didn't rent it for very long, because 1 month later, after the free month had expired, and you're going to hear evidence to this effect as well, the defendant is seen on surveillance footage going back to the U-Haul storage facility and closing out that U-Haul unit that he had rented. Again, you're going to hear from an employee who helped him with that process. You're going to hear that the defendant was in a rush. He wanted to get out of there as soon as possible, and he cleared out the entirety of that storage unit as well. And then he made his way back to Waukesha County. What he didn't know at that time was that the police had obtained a GPS warrant for his car. So when he left Waukesha County and traveled to the Fox Cities, the police were following him. They wanted to see what he was up to. And so what they ultimately did was they effectuated a stop, and then they seized the vehicle that he was driving as well, from Outagamie County all the way back to Waukesha County. And then they found the holy grail of evidence. The evidence is going to show in the defendant's vehicle. They found in the trunk of his vehicle, after they went and got a search warrant, by the way. So they seized the vehicle, but the police then went and got a search warrant. They searched the trunk of his vehicle, and they found, and you see it depicted here at the bottom of this picture as well, a 1939 Luger firearm. And the police did 2 things with this particular firearm. They're going to be very, very important in this case. The first thing they did is they packaged up this firearm, and then they mailed it to the state crime lab, in Milwaukee. And there's an individual who works at the crime lab by the name of Jessica Crawford. She's a firearms and markings expert is her title. And so what she did, and you're going to hear from her as well throughout this case about her process as well, you're going to hear that Ms. Crawford tested this firearm and found, despite it being a very old firearm, that it was fully functional. It was working just fine. It was capable of recycling rounds through and firing bullets. But the other thing, and this is perhaps even more important than the fact that the Luger was fully functional, Ms. Crawford took 2 projectiles that we recovered from Carlos. The one that came out of his head from the autopsy, and then the one that was found under him in the tarp where his body was discovered at the apartment complex. She had both of those projectiles. And then she had, in addition, her own library of ammunition that she had in the lab as well. So she test fired the rounds that she had from her library of ammunition, and then she compared those rounds with the 2 projectiles that we know went through Carlos. And what she found, and what she's going to testify to, is that both projectiles bear markings that are similar. And when a gun is recycled through a firearm, through the barrel of a firearm, it leaves certain markings so that you know that it came from that particular firearm. Never has it happened in the history of firearms that a bullet has bared the same markings, and she will tell you this, that came from 2 separate guns. So the bullets that we pulled out of Carlos came from the weapon that we found in the defendant's trunk of his car. But we're not done, because not only did the police send the gun for testing, they also swabbed the gun for DNA. And they sent the firearm, or they sent the DNA swabs that they tested. And they also had Mr. Lychwick's DNA as well. That was obtained pursuant to a buccal swab as well. They sent that to the lab as well. And what they found, there was a DNA expert that actually tested this as well. And each person has their own DNA profile, right? The only exception to that is if you have an identical twin, which is not true in this case. Mr. Lychwick's DNA profile was found on that murder weapon that was in his truck, or it was in his vehicle, excuse me. And what you're going to hear is that it was a single source DNA profile, not a mixture where multiple people are contributing to this profile, but a single source DNA profile. And that the lab's conclusion was that there was very strong potential for inclusion, that Mr. Lychwick's DNA was the profile that was found on that murder weapon. That is the highest support, that you will have the highest probability of standard that the lab has in terms of DNA. And the DNA expert will explain more to you this as well. We also, as part of this investigation, obtained Mr. Lychwick's phone. We wanted to see what he was searching on his phone. People search for all kinds of things on their phones, right? And we found some very incriminating searches on his phone as well. First and foremost, a brief just housekeeping matter regarding the email address. Conrad Lychwick, you're going to hear testimony in this case that although the defendant's legal name is Kevin, he prefers to be called Conrad. In fact, you're going to hear that he would correct people when they would call him Kevin rather than Conrad. So not only do we know that this is his phone, because we wrote a warrant and were able to look at what he was searching, we also know that that's his email address. And so that was associated with his phone as well. And what we found when we looked at his phone was some very suspicious findings. 1 week, just 1 week after Carlos was never seen again, was never heard from, we have the defendant searching carcass movement, processing and disposal. How can I dispose of spoiled food safely? Large plastic bags and where to find them. Maps of landfill in Wisconsin. This is very suspicious, and from the state's perspective, we believe the evidence will show that this is because he was making certain measures to see how he could dispose of Carlos's body after he had killed him. And there were additional certain things on his phone that were incriminating as well. November 25th, 2024, he went to Google, his phone went to Google and searched Waukesha News for November shootings. There had been no shootings in Waukesha County at that time, and we hadn't made public the fact that Carlos's death was by virtue of a shooting as well. Once again, much like the comment that he made during the execution of the search warrant at his house, only the killer would know this sort of information. So, ladies and gentlemen, there's two counts, as Judge Maas just explained to you. There's first-degree intentional homicide, and then there's the second count of hiding a corpse. I'm not going to spend a great deal of time on this as well. You'll get the full jury instructions at the conclusion of the case at the evidence. But I just wanted to define a couple of these terms for you as you listen to the evidence. So the term cause, the first word in that, means that the defendant's conduct was a substantial factor in causing Carlos's death. Well, the evidence is going to prove to you that he shot him twice. Shooting somebody twice, once in the face area, pretty obvious, right? That's going to cause somebody to die as a result of that. And then intent to kill, again, you have the mental purpose to take the life of another human being, or you're practically certain that your conduct is going to cause the death of another human being. Again, I've already touched on this. We have the notes from the apartment talking about operations and neutralizing specific targets. I didn't use the word motive, and Judge Maas already explained this to you. I'm not going to repeat that. Motive is different from intent. We have to prove intent to you, but we don't have to prove motive. Now, that's stated more simply, we don't have to prove why he did it, but we have to prove that he did it and he acted with intent. And you'll get a jury instruction on that as well. And then we have the second count of hiding a corpse. You see the elements up there as well. You're going to hear from Detective Stern in this case. I've already touched on this about the location of the pile that had Carlos's remains in it. You're going to hear that it was Detective Stern's conclusion that that pile was deliberately set there. We will show you a number of pictures. You'll be able to see that there were twigs and other things and branches and things over top of this pile, almost as if the individual who put it there did not want this pile to be found. And again, we'll show you evidence on that as well. And again, the fact of the trail cameras that I've touched on earlier as well, the fact that the defendant was seen walking around in this area at very odd times of night, okay, when there was nobody out. Again, evidence of that as well. So that's the second count. And finally, ladies and gentlemen, I'm going to conclude with this. You're going to hear from a number of witnesses. You're going to hear from police officers. You're going to hear from specialists. You're going to hear from eyewitnesses. You're going to hear from people who worked on this case. We have a DNA expert. We have a firearms expert. We have a medical examiner, a cadaver dog expert, a botany expert, and even a forensic anthropologist. So this is going to be a lot of experts that's going to come in and testify. The evidence is going to show that this investigation was not a rush to judgment. This was not a giant conspiracy. This is not an attempt by the Waukesha Police Department to railroad Mr. Lychwick. The police put a lot of time and a lot of effort into this case, and it was ultimately the conclusion that they had by following the evidence that Mr. Lychwick was the individual who was responsible for murdering Carlos in this case. It's the conclusion that is only supported by the evidence that we're going to present to you. And as we were sitting down and thinking about what is the most, proper or perhaps the best framework to present this, we came up with the idea of a puzzle. When you sit down to do a puzzle and you put the first couple of pieces in this particular puzzle, you may not be able to see, the full picture of the puzzle. But as you add pieces to it, and in this case, the pieces would be the evidence that we're going to present to you, and you hear more and more about the evidence that we have and how we present it in, then you start to see the bigger picture emerges. The puzzle starts to come in full focus. And that's what this case is. So Googling, for example, how to dispose of spoiled food safely may seem pretty innocuous. But when you consider all of the other evidence that we're going to present, what it is it shows, it's just one more piece of the puzzle showing that Mr. Lychwick is the individual who's responsible for the murder in this case. And I'll leave you with this. When you've heard all this evidence, and we've had an opportunity to address you in closing, and we're going to come before you and ask you to find Mr. Lychwick guilty of both of these serious counts in this case, I want you to keep in mind all the evidence that we're going to present to you. Because for all this evidence that we're going to show you, and I haven't shown you everything, right? We've just shown you some of the most compelling pieces of evidence. For all this pieces of evidence to be true, and for Mr. Lychwick not to be the individual responsible for murdering Carlos, he has to be the unluckiest man in the world. Thank you very much.
Oh my gosh, I don't know what.
Thank you, Attorney Tombasco. Mr. Lychwick, would you like to give an opening statement at this time?
Yes, I would.
All right, you may proceed.
Ladies and gentlemen of the jury, quite simply, I am not guilty of this crime. I feel sorry for my poor neighbor, but I did not know him well enough to have any animus against him even, and I have never killed anyone in my life. The largest warm-blooded animal that I've ever killed was a skunk that walked in front of my car by accident years ago. I am not a killer. The police in this matter have a largely circumstantial case. I don't know how exactly they circumvene on me, but I simply did not do this. I am unprepared for this trial. I am in poor health. I was in poor health and doctoring at the time that they arrested me, and they knew that. The police have made gross exaggerations in their reports, and I do not recognize that firearm. This is the first time I am seeing a picture of the firearm used in this murder, and I do not recognize it. That was not in the trunk of my car when they stopped me. They did not have a warrant when they stopped me.
Objection.
Oh!
The objection is overruled at this time. The warrant was discussed in the state's opening. Mr. Lychwick, though, I will remind you that you're venturing a little into argumentative territory. So I want you to just focus on what you believe the evidence will show, and you can infer arguments in your closing arguments, okay?
All right.
Go ahead.
I caught some gross exaggerations immediately with the prosecution's opening statement here. They're telling you that Detective Stern had presented me with a copy of the search warrant, which he did, when they went and destroyed my apartment. And in the search warrant, Mr. Carlos's name was on the search warrant. And I knew everyone in our building there, down at the bottom of the hill here, knew that Mr. Carlos was being looked for, that he was missing. Detective Pavlik of the Waukesha Police Department took an initial statement from me the night that they were examining the crime scene. When I was returning from a social engagement, I gave my statement to him, and he asked me if I had seen Mr. Carlos around anywhere recently, and I told him, of course, that I had not. This is a gross exaggeration. I don't know how the detective can wear his badge with honor and blow something like this out of proportion and use this as an excuse to center on me in this affair. I was never walking around in the area where the poor man was found. I was never in that area. And yet the state is telling you that I was walking in the area where the poor man was found. I was not. I was never in that area. Quite the contrary. The man who discovered the body and was an initial suspect of this crime, Mr. Polly, who is now missing.
Objection, relevance.
Mr. Lychwick, I'm going to sustain that objection. I'm not sure how the testimony is going to come out regarding that, but I think that's something that's outside the scope of this trial. So I want you to focus on the evidence that will be shown in this trial. You may proceed.
I would like to say that Mr. Polly was the one who was.
Objection.
I don't know what his next statement's going to be. What were you going to say, Mr. Lychwick? You want to say that Mr. Polly is...
Mr. Polly, a very suspicious character in this building to begin with, was seen quite frequently in the area where the poor man was found, where the remains were found.
I object.
Poor man.
Hang on one moment. Attorney Tombosco, are you objecting to that statement?
Absolutely.
Why is that?
Because it's contrary to this court's pretrial rulings regarding Denny evidence.
Mr. Lychwick, I'm sustaining that objection. At this point, I want you to focus on the state's opening, your opening, the evidence that you believe will be presented. And I'm reminding you of the scope of some of my pretrial rulings about what can come in and what cannot come in into evidence. You may proceed.
The defense, in my defense here, you know, the prosecution is maintaining that Mr. Lefebvre's camera captured me walking around in the area that I lived in. I had reasons for being out the few times that I went out at night. As anybody, I'm living in a wilderness area. We're not allowed pets in my buildings. I put food out for the rabbits. I carry a rake to clean up the area under the tree where I leave the lettuce rinds that I give the rabbits. I also curious as to where the local possums that are supposed to hang out in our pine trees live. And I was accused by the prosecution here of carrying a firearm when I was out. As you'll see in the videos that Mr. Lefebvre took with his trail camera, that is not a firearm, and it has been recognized as not a firearm. If the state maintains that it is, I will object to that because it is a flashlight in an old camera case on my belt. I did not walk around with a pistol. I did have a pistol in one of the bags that they found during their illegal car stop, and it was
Objection.
The objection?
Again, he's violating the court's pretrial ruling.
Okay. Mr. Lychwick, there were motions heard before the trial about legality and illegality of any searches. The court has made a ruling that the searches in this case were valid and they were constitutional. So I'm not going to permit arguments that the searches were not legal. You may continue.
Well, the police did not have a search warrant at the time that they took my car.
Objection.
Again, that, Mr. Lychwick, is something that would be ruled on pretrial. It's not a trial issue for this jury to determine whether or not there was a warrant present. You may continue.
Oh, I'm up against a lot here, ladies and gentlemen of the jury. I am a God-fearing man. I'm telling you, I did not know the poor victim. I did not even know him to where if I saw him in a store or he saw me, we would have said anything to one another. It is a 16-unit apartment building. We have multiple people living in each unit, and I have my lady friend, and I spend a lot of time away from my 16-unit building, doing my own business, minding my own business. We all are good people in that building. We mind our own business. As I told the Channel 4 reporter who interviewed me shortly after Mr. Carlos was found, and this whole thing blew over. And as I told Channel 4, Leslie Clough of Channel 4, who interviewed me, this whole thing was bizarre. Right around Halloween, they find the poor man, and nobody heard anything or saw anything. It was just bizarre. And as I told Ms. Clough, we're all good people in the building. We mind our own business. We're on different schedules. Again, as far as me and the victim go, I really never saw him that much. The closest look I've ever had of him was at the picture they just showed on the screen this morning. There was another misstatement made by the prosecution, and the prosecution is maintaining that that I wrote some that they had evidence of the victim's name in my apartment written on a piece of paper. That is totally false. I had nothing at all with the victim's name on it. I did not know the victim that well. I'm sure he was a very nice man and everything, but I would have liked to have known him probably, but I simply did not. We were all on, I say again, different schedules, moving around on different time frames and timelines. I am acting as my own defense because...
Objection.
Mr. Lychwick, I don't know the jury needs to know the reasons for that. It is your decision to make. You have exercised your right to represent yourself. The court has granted that request, and that's the end of it. The reasons for that or behind that is not anything the jury needs to consider.
It was an excruciating decision, Your Honor.
Mr. Lychwick, that's not anything the jury needs to consider in trying this case. That's not for the jury to consider in their deliberations, okay? So move on, please.
Well, I enter these proceedings under protest as well, because I am not an attorney, and I have no access to my assets right now, and I had no access to telephone or computer.
Judge, I'm objecting to this. I don't see the possible relevance to the evidence.
The objection is sustained. This is all not relevant, Mr. Lychwick. You are in court now representing yourself. You are held to the standards of an attorney. And you, if you have anything else regarding what you anticipate the evidence to show in this case that's relevant, you may present that.
So I saw Lori Vallow Daybill give closing arguments in
I have developed
I saw
evidence through the discovery process in this case that strongly will prove that the Waukesha Police Department, namely 5 to 7 of these officers and detectives involved in this case, have compiled this evidence on their own. That they have falsely introduced this evidence against me. It is not just. It is not legal what they are doing. I came across hard evidence of their abilities and their intents and their lack of ethics when I received discovery evidence in the form of Axon body cameras from the night that they took my car on 1st December 2024. I found that there were sections missing from the body camera footage, including audio sections that were reworked and redubbed. I have not been able to get the state public defender to provide for the minimal cost to analyze the footage and the audio section of the footage to prove my point and to prove tampering and tainted evidence in this case, which should have resulted in this case being thrown out at least 8 months ago. It should not have come this far. But I have not been able to get my only source of defense, which was the state public defender's office, who I took at face value, owing to their title, to provide me with the minimal, like I say again, the minimal amount of cost to develop the evidence, which is a very cost effective and relatively easy method that an amateur could process this evidence and show from the body camera footage and pulling it apart on a video editor, which is present on any computer. The fact that the Waukesha Police Department had doctored this film footage and doctored the audio portion of the film footage. What they cut out was the fact that they bumbled the car stop. It was completely contrived. As soon as I was pulling into the gas station from Appleton, Wisconsin, where they followed me apparently,
oh my God.
They stopped me
This
at the
is
driveway of the gas station, and Officer C.D. Baca exiting his police cruiser along with Officer Tyndall trip over each other and start laughing. One says, stopped going 35 and a 25, and they start laughing. And the other one says, stopped going 35 and a 25. And they cut that out. And then I was offered a ride home when Detective Stern over here offered me a ride home because he said he was going to seize my car and have a warrant typed up at the police station so they could search the car. And I accepted the ride home down the hill from the Quick Trip gas station here on Pewaukee Road because it was quite cold and I wasn't feeling well. And Officer C.D. Baca of the Waukesha Police Department offered to take me home. And I tried making some small talk with him in the police cruiser. I just asked him if he'd catch any of the football games on recently or anything. And then when he let me out of the police cruiser in my driveway, which was dark and foreboding at that hour, being winter going towards 6:30 in the evening, Officer C.D. Baca did proceed to threaten me. He stated that I had better back them up on the fact that they're stopping me for speeding, going 35 miles an hour in a 25 mile an hour zone, which, by the way, does not exist on Pewaukee Road in the area where they stopped me. And I looked at he was standing in the shadows with another officer behind him, who also pulled up in a police cruiser in my driveway. And they were holding on to their pistols. They had their hands on their pistols in a threatening manner. And I didn't know what was going to happen. And I looked at them, which you'll still see on the body camera footage if they show it. My reaction to C.D. Baca's threats are, yeah, all right, God. And I just wanted to get out of there and get into my apartment at that point. That they they left into the body camera footage, but otherwise they have me saying, sure, the words coming out of my mouth were not those that I actually stated that night, which is tampering with the evidence, which is fraud. I was made to say, as you'll see on their version of the body camera footage, definitely, I agree with you. You know, have a good night and all this kind of stuff. That was not in the original Axon body camera footage filmed that night by the two police officers. That is tampering with evidence. I have tried to bring that before the court. I wanted to. I have the chain of custody of that evidence here, which shows considerable attention to Officer C.D. Baca's Axion body camera footage and Officer Tyndall's body camera footage. I can show that according to the jargon used with digital technology now, they call the data acquired by the filming and the audio portion of any body camera footage. And indeed, many of the footage that we ourselves are prone to photographing when we use our cell phones and everything is called checksum data. And in the evidence that I have in my disposal, which was presented to me on discovery by the prosecution and the police, I'm assuming they didn't think that me and my defense would come across this, but I did. And it clearly shows that they have changed this checksum data at least twice on C.D. Baca's body camera footage. Again, I strongly urge the jury to consider the tampering of evidence in this case. This case should have been dismissed at least 8 months ago when I discovered this evidence, which was given to me late by my first state public defender attorney, who was grossly inadequate and not providing me the correct defense that I needed, and I was forced to terminate him as my public defender. I emphatically deny any involvement in this crime. I am a law-abiding citizen. I am a good Christian of the Lutheran faith. I am a responsible citizen. I am an ex-police officer myself. I served as a security police officer in the United States Air Force. If this trial proceeds in a manner which should deny me the justice that, in a large part, I am really not qualified
We know.
to oversee, as I am not a trained attorney. This will be a travesty of justice. I ask you to please consider the fact that a serious wrong is being perpetrated here. It will serve nobody if the state and the police, the several police officers of the many good police officers in the Waukesha Police Department have their way here. For one thing, the victim and his family will not receive justice. And they should definitely receive justice. The killer or killers, in my personal opinion, I think more than one person was involved in this homicide.
Objection.
Mr. Lychwick, consistent with the court's pretrial rulings on Denny evidence, the court will sustain that objection. It's also, the court will sustain the objection. Anything else, Mr. Lychwick?
Well, yes, Your Honor. Is that Denny evidence?
Yes.
And I must ask you to consider the fact that a person is considered innocent until proven guilty in this country. And I certainly am not guilty of this crime. And if a travesty of justice is allowed to take place at the culmination of this trial, the perpetrators of this crime will be allowed to roam free and perhaps kill again. you should consider that. The police should be put on the track of whoever did this to this man again, because while I'm in custody here, the state is under the false impression that they have their man, if you will, and they're not looking for the killer anymore. That is a serious miscarriage of justice in itself. That is a serious safety issue for public at large. I ask you to please weigh that in here as well.
Hey, China, how are you?
Ladies and
Anything else,
gentlemen of the
Mr.
jury,
Lychwick?
I ask you to do your best, and I thank you for coming today and doing your duty as a citizen. I would have done the same thing. Thank you.
Thank you. All right, ladies and gentlemen, I will remind you that opening statements are not evidence. At this point in this case, you have heard exactly zero evidence.
Zero.
There's no evidence in this case yet presented to you. The only thing that's been presented is opening statements, and those are not evidence. So as you take a break for lunch, I
Zero
will
evidence.
caution you to not discuss this case amongst yourselves. Don't come to any conclusions yet. You can certainly call to loved ones and check in and just state that you got selected for a jury. This is the trial you're on, but otherwise don't say anything about the case so far or this process. Also, do not seek out any information on social media or news or Twitter or X or anything like that while you are on break. It is 12:27 right now. I want to give you time to take a break and get lunch. Let's reconvene at 1:40 p.m. and we should be ready to start the evidence at that time.
All right, Jerry.
Right. I want to check on see if the track meet trial is, there's a couple of other trials going on, but I want to check on sorry, I need to remove this. Okay. I want to check on the track meet trial, because that is like the biggest thing going on right now. Sorry, I sound weird still. My tongue is still swollen. So excuse me. I'm looking for some updates for Carmelo Anthony. As we all know, that is a very heated. So apparently this has hit a very. Let's see. Oh, So I want to know where is I want to know what happened to what's the guy's name that started all of this shenanigans? Charlton. Charlton. What's his name? The guy that started all of this mess. I want to find some actual update. If there's any updated anything on the case, because the defense is making their case right now for Carmelo Anthony today. And from what I understand, they don't have a case. From what I understand, I mean, it's just unfortunate. I mean, Carmelo just made a really stupid decision, and I don't think it's going well. Unfortunately, I mean, so Queen Sheba is there. She's so wow. I just it doesn't. I just don't think it matters. Like it's really, really, really stupid the whole situation is stupid. This whole situation is stupid. It's two teenage boys that got into an argument and one of them took it too far. That's the bottom line. One of them made a really dumb decision and that's it. That's it. And what's the guy's name? Charleston White. Is that his name? The guy that made this into something that it didn't need to be. Now it's turned into this whole thing. The people are being so ugly, and so racist. There's a guy outside the courthouse that's like, the only good cracker is the dead cracker. Like talking about, I'll wrap you up and set you on fire. That's just mean. That's like so rude. People are out there like, we're just tired. Like, first of all, what does it have to do with anything? That has nothing to do with nothing. This is just two teenage kids who decided to. It just makes no sense. It makes no sense. And why everybody's so mad about it. I don't understand why everybody's so up in arms about it. If it was the other way around or any way around, or if it was one, it wouldn't even matter. I just don't see how it wouldn't even matter. This just doesn't make sense. Why everybody's so pissed off about it. But it looks like the case is looks like it might go to the jury today. They might do closing arguments today. So if that's the case, this is the fastest trial. But I mean, there's not really much more to give about it, much more to say about it. I mean, I don't know what else they could. There's no more witnesses to call unless they're going to call Carmelo. So and I don't know what is up with Waukesha County. Is that where we're at? Waukesha County and people representing themselves. But in Wisconsin, that seems to be what they want to do. Because that's where what's his name? Dang it, what was his name? That represented himself. Then we have a boat trial, a millionaire boat crash trial going on. Florida versus George Pino. I don't know. Oh my. Oh my gosh, they showed the jurors. Oh my gosh. Oh my gosh.
That the state intends to use during the testimony of the witness. Obviously, I don't know myself and see what that is. That's how
This is a
further scrubbed.
like a DUI boat.
This afternoon.
Would it be okay just if you email it to me?
Absolutely, as long as the defense doesn't have an objection, we'll do that during a break.
Of course not. Yeah, that's fine. Okay.
A millionaire, not a billionaire, a millionaire. Oh my God. don't cry. Shame on you. Shame on you. Woman.
Online newspaper. No.
Oh, she looks like a Yankee.
Has anyone attempted to speak with you or in your presence about this case?
No.
Okay. All right, very well. Ladies and gentlemen, you have been selected and sworn as the jury to try the case of State of Florida versus George Pino. As you know, this is a criminal case. Mr. Pino is charged with 1 count of manslaughter and 1 count of vessel homicide, operation in a reckless manner. It is your solemn responsibility to determine if the state has proven that Mr. Pino has committed the crimes charged beyond the exclusion of a reasonable doubt. Your verdict must be based solely on the evidence or lack of evidence or conflict in the evidence and the law. As I explained to you during jury selection, this document in my hand called the information, that is the charging document. It was filed against Mr. Pino, but it is not evidence in this case, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide what laws apply to this case and to explain these laws to you. It is your responsibility to decide what the facts of the case are and to apply the law to those facts. Thus, the province of the judge and the jury are well defined and do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys the opportunity to tell you what evidence they believe will be presented during the trial. I remind you what the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final arguments. And following the final arguments, I will instruct you on the law that is applicable to this case. After the instructions are given, anyone chosen as an alternate juror will be released, and the remaining jurors will retire to consider the verdict. I admonish you, you are not to form any fixed or definite opinions about the merits of this case until after you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you are not to discuss this case amongst yourselves. During the course of the trial, we will take recesses and meal breaks. During these times, you're allowed to go about your personal business. You cannot discuss this case with anyone at any point while you are still on this jury and before you are discharged. You are not permitted to let anyone to speak with you about the case or in your presence about the case. If anyone attempts to speak with you about this case or in your presence about this case, please remind them that you are on the jury. If they persist, please report that to Renee immediately. This prohibition applies to everyone in the courtroom, the attorneys, witnesses, staff, and third parties. If you see us at any point outside of this courtroom, we're going to ignore you. And don't take that personally. All of us, everyone in this courtroom, is invested in maintaining the integrity of these proceedings. This case must be tried by you. This case must be tried by you only on the evidence presented during the trial and in your presence and in the presence of Mr. Pino, the attorneys, and myself.
So Mr. Pino is being charged with.
You are not allowed to visit any of the places that may be described in the evidence, or read or listen to any reports that might exist about this case. You are not to discuss this case with anyone.
This is from 2022.
You are not to speak with the attorneys, Mr. Pino, any of the witnesses, or anyone else about this case until you have concluded your deliberations and
He was
discharged.
driving a 29-foot boat.
The person accused, in this case, Mr. Pino, has an absolute right to remain silent.
After a
At
birthday
no
party,
time does he have a duty
carrying
to
14
prove his
people,
innocence.
including his
From the
wife and
exercise
12
of one's
teenage
right to
girls.
remain silent, you may not draw any inference of guilt or hold it against him in any way. The fact that the
Boat
accused
accelerated
does not take
around
witness
43 to
must not
47
influence
miles
the
per
verdict
hour and
entered
slammed
in
into a
discussions
highly
in any
visible
manner
day-glow green
whatsoever.
channel marker.
The attorneys
Boca
are trained in the
Chica
rules of
Key.
evidence and trial procedure.
Impact
They have a duty
threw
to make
all the
objections they
passengers
believe are
into the
proper.
water.
When an objection is made,
It
please
killed
do
a
not
17-year-old girl,
speculate as
Lucy
to why it
Fernandez,
was made.
and trapped
Likewise, if an
a nut
objection is
under
sustained,
that became
the
trapped
duties
under
are
the
prevent
capsized
a
boat
witness
and
from
drowned.
answering a
Another
question
teenager,
or
Captain
prevent a
Hughes,
piece of evidence from
suffered
coming
permanent
forward.
life-altering
Please don't
disability.
speculate as to what might have been said or what might have
Pino
occurred
pleaded
at the witness
not
stand.
guilty to
Please.
second-degree manslaughter and vessel
Sometimes
homicide.
during the trial, and you saw it during our jury selection, it's
22.
necessary for me to confer with the attorneys in what we call
Pino's
sidebar
defense
conferences.
team has argued that
I'm
the
gonna put
crash
on the
was a
white
tragic
noise.
accident
This is
caused
not
by the
for
wake
your
of another boat.
concern or
Behavior
consideration.
following the collision was
A
due
matter
to
of
head
schedule.
injury, not
It could
intoxication.
be a matter of law, which is for me to decide.
Oh, this could be
I call these
interesting.
sidebars, or they might be requested at times during the proceedings. If I think that something might take a little bit longer than a few moments, I'm gonna likely take a break at that time, okay? I also try to keep sidebars at a minimum. So if counsel requests a sidebar and I ask them to reserve, it doesn't mean I'm mad at them.
I mean,
Many times I can
2022?
anticipate what we need to discuss, and I might
that
ask them
clearly,
to
that
reserve
means
and then handle it when we take a break. So
this
try to keep them at a
investigators
minimum.
were finding
Keeps the
dozens
flow
of
of the
empty and
proceedings
partially
going.
consumed alcohol containers on the vessel.
In addition, let me talk to you about note-taking. Renee is
Well,
going to hand to each one of you an envelope.
they weren't his, but they
Outside
could have
the
belonged
envelope,
to
there is
teenagers.
there's a white tab on the outside of the envelope. Inside the envelope is a notepad and a pen.
I
Please
mean,
remove the notepad and the pen from the envelope. If you would please, write your juror number on the white tab on the front of the envelope. This is how we will identify that envelope and that notebook as belonging to you. And that is your notebook to use if you wish during these proceedings. Make sure everyone write their juror number. These notebooks are not seen by anyone else but you. It's for you to use if you wish. At the end of each session, and some at recesses, I may ask you just to leave them in your seats. If you take breaks, Renee may collect them during breaks. At the end of each session, Renee will take these envelopes from you with your notepads inside. They will be in a locked drawer in the office. No one will have access to them. Let me talk to you though about note-taking. I permit the jurors to take notes during the proceedings. And some people take notes, some people don't take notes. It's not a requirement. But the caution about note-taking is this. Please do not get so
I
wrapped
would be
up or
surprised
focused
if they could,
or
if he
concentrated on
gets
taking notes
found guilty
that you miss something.
criminally.
Because your job
This is another one of those,
to rely on your independent
I
recollection
don't know,
of
because
evidence and testimony presented to you during the proceedings. So you have to be alert, you have to be listening, you have to be observing. So note-taking.
he could be like obviously sued
Don't let it distract you.
monetarily.
You're not
and wrong
listening,
with
you're
this,
not paying attention, you miss something, okay?
but
Because again, they're for your guide and they're used only to help you.
they win.
Recalling what
Right
transpired,
now we're watching
to
the
refresh your
you know,
memory of what
Morgan's
transpired.
trial because the other one is
That's how notes can and
this
should
one's
be
just starting as
if you
well.
wish to take them.
This one is from
Very well, let's begin.
2022. where George Pino is on trial for crashing his boat that had 12 teenage girls on it and him and his wife. And one girl died and another girl has life-altering disability. And they're saying that he was drunk. That's okay.
Sorry, may it please the court.
Ooh, chicken salad, yum.
Ladies and gentlemen of the jury, thank you for being here.
But he's
By way of introduction again, my name is Laura Adams. Along with me is Mr. Jonathan Borst. And also we're going to be assisted from time to time through this trial by a law intern, a law student who's interning at the state attorney's office, and his name is Juan Ramirez.
I mean, they found a bunch of
This,
alcohol
ladies and gentlemen,
on the
is a
boat.
case about responsibility and accountability.
I don't
Or
know.
I should say, the lack of both on the part of the defendant in this case, George Pino. The evidence is going to show that on September the 4th of 2022, this defendant took his wife, his 17-year-old daughter, and 11 of her teenage friends out on his boat, and he wound up plowing right into a huge channel marker that ironically was placed in Biscayne Bay to keep boaters safe. As a result of his complete abandonment of good judgment and responsibility, 17-year-old Lucy Fernandez, her given name is Luciana Cristina Fernandez, is dead. In the aftermath of causing Lucy's death, this defendant avoided accountability by telling the police a fabrication of how this boating crash occurred. And he maintained that falsehood long after the day of this tragedy. The evidence in this case, ladies and gentlemen, will show you this was not a mere accident or a momentary lapse in judgment. The evidence that Lucy is dead because the defendant failed to do the most basic things that the rules of the water require. Things like maintaining a proper lookout, things like operating your vessel at a safe speed for the conditions, avoiding situations that can cause a collision, or as you may hear from time to time in this case, an allision. Collision technically means two boats striking each other. Allision is a boat striking a stationary object, whatever term you want to use. Don't crash into things. Moreover, you are to travel when you're in a narrow channel on the right-hand side of the channel. We're not in England. We don't drive our cars on the left side, and we don't operate our boats on the left side of the channel. This defendant drove his boat after consuming alcoholic drinks that was full of teenagers who also had been drinking alcohol right into that big steel channel marker in Biscayne Bay in broad daylight, a channel marker that had a day glow green square above it with the number 15. A channel marker that he had passed by a multitude of times because this was his water playground going to and from a location, which I'll talk to you about in a moment, up to a sandbar. He hit that channel marker, ladies and gentlemen, as he was accelerating through the channel, going from speeds of 43 miles an hour to 47 miles per hour. He struck that steel channel marker at just under 50 miles per hour.
Is there a speed limit?
The witness who will tell you how this crash happened has no bias, no prejudice, and no sympathy. This witness has a perfect memory. And this witness is not swayed by money or privilege or power. That witness is global positioning system data, better known as GPS. The GPS from the defendant's boat is how we know the way that this crash occurred, because the GPS told the truth about what happened. George Pino did not. But before I get into the details of the GPS analysis that was done in this case, I'd like to give you a little bit of an idea of what was happening on September 4th, 2022. The defendant, George Pino, and his wife, Cecilia, had planned a wonderful weekend celebration over the Labor Day weekend. Their younger daughter, who was also named Cecilia Pino, but went by Little Ceci, named after her mom, she was going to turn 18 later that week. And so the family invited a bunch of Little Ceci's friends to come to a location called Ocean Reef Resort,
Sourdough bread sounds
to
awesome.
have a weekend of fun, hanging out together, going out on the boat, having a celebration dinner. At around 2:52 that Sunday afternoon, they got into George Pino's boat. 12 kids, the defendant, and his wife. Before leaving for Ocean Reef Resort, before leaving the resort, however, that boat was stocked with some food and drinks. And the drinks that were stocked on that boat were not just water, were not just sodas. There was alcohol, lots of it stocked on that boat. Now the plan was to head out you all see okay? The plan was to go from here, which is where the location of Ocean Reef is, where I'm circling this blue dot, and to traverse across this little narrow waterway, and then head up toward this location, which is called the Cutter Bank Channel. Now, for those that might not be boaters, what you'll learn in this case is that a channel is an area of the bay that's dredged out to be deep, because a lot of Biscayne Bay is relatively shallow. And if a large boat that has a keel under it has a draft that's too far, that boat's going to run aground, and that'll cause a danger to everyone. So in areas where the bay is shallow, there will be dredged out locations. And to keep people safe and to let boaters know where they can maneuver their maybe larger vessels, there are what's called channel markers on either side. They're big steel poles, and on one side of the channel, there will be odd numbered markers in day glow green, and on the other side, there will be even numbered markers in red. The plan for that day was Mr. Pino went up through this channel, and he and other boats were going to rendezvous at this location here, which is called Billy's Point. It's a popular location where people will come to, dock their boats, tie their boats up to other boats, and people will socialize, have fun, sometimes drink alcohol, have food, listen to music, things of that nature. However, when they get to this area where I have the orange dot, Billy's Point, one of the boats that's kind of part of this group, it's too big to dock there. You can see where the water along here is, or this is like a lighter blue that shows shallower water. So what they do instead is they head up further north here to where I have this red dot. It's slightly deeper water, and that's where the defendant and several other boats basically stay for a few hours, okay? So once they get to that part of the sandbar where the water is a little deeper, the plan was at the end of their time there, they were going to return back down to Ocean Reef because the defendant had planned a surprise party for his daughter. And it was going to be a catered dinner from like 9 p.m. to 11. To give you a little bit better of an idea of how the channel works, I have this exhibit also. And this gives you a little bit more of a close view of where the defendant was going to travel. So here we have where Ocean Reef is. Here is the area where he would traverse. And then this area here that I'm circling, that is called Cutter Bank. And there are channel markers, 15, 14, 13A. There's channel marker 12 all along this channel so that boats can safely travel through it, okay? And I have one more that's just a little bit closer so you can really get an idea of where those markers are through here. And all of this evidence you'll see during the trial. This isn't your only chance. When the defendant was traveling north to get up to where the sandbar was, he was traveling at a pretty moderate speed, maybe like in the 30s or so. Also, he was navigating the boat in a way that's consistent with seeing other vessels because, again, this is Labor Day weekend and the waters are a little busier during holiday weekends than they are, during the business day. The defendant and the kids and his wife, all on his boat, get up to the area of the sandbar at about 3:23 that Sunday afternoon. Now let's talk a little bit about what was going on at the sandbar. There, Mr. Pino dropped his anchor, and the girls that were on his boat would, hang out with each other. There was another boat that was, the owner was friendly with Mr. Pino. He had some boys on his boat. So the girls and the boys were swimming back and forth with the boats, listening to music, having a great time. They would hang on to floating devices, interact with each other. And yeah, they were drinking. The teens on the boat, on Mr. Pino's boat, helped themselves to alcoholic drinks that the Pinos provided. The adults kind of knew what was going on, and the thought was, look, if kids are going to drink, it's better if they're drinking in the company of hopefully responsible adults rather than do something on their own. But the teenagers weren't the only ones that had consumed alcohol that afternoon. So did Mr. Pino. This was really one big happy party. Here's a picture of most of the girls that were there that afternoon. Many of these girls knew each other from elementary school. What a great day this would have been. Oh. This girl here in the white bathing suit with the cute little flowers, that's Lucy. At one point that afternoon, Lucy's mom and dad, who were also at Ocean Reef, had been asked by their daughter, Mom, Dad, come on out to the boat. We're going out with the Pinos. Come meet us out at the sandbar. Now, Lucy's dad, who you'll meet during this trial, he was kind of tired. He had golfed earlier in the day, but he and his wife figured, if your teenage kid is saying that she wants to see you, even when she's with a lot of her friends, let's suck it up. Let's go. We're going to go see our daughter. And so Mr. and Mrs. Fernandez took their own boat out and wound up rendezvousing with where the Pino boat was and a couple of the other boats that were there. What you'll learn is that Mr. Fernandez didn't really want to stay a very long time because he had plans later that day to watch the game between FSU and LSU with his dad, who lived at Ocean Reef. So his plan was to go out there, see his daughter, engage with the people that they all knew, and then try to leave by around 5:30 or so that he could be back in time to clean off the boat, get cleaned up, and then go over to his dad's condo on Ocean Reef. While Mr. Fernandez is there, he too consumes some alcohol. he winds up toward the end of the day getting ready to leave. And as he and his wife are getting ready to leave, they kind of thought about what a great afternoon it had been. They were glad that they'd gone out to see their daughter. At one point, their daughter swims over to the boat and she asks her dad for some sunscreen and a hair tie, to make a ponytail with her hair. She hugged her dad before jumping back off the boat. And that was the last time Andy Fernandez ever got to hug his child. Before leaving, Andy took this picture with his phone. You can see this is the defendant's boat. You see people floating around. You see people on the boat. What could have been more fun than being lucky enough to be out on the waters, to have a weekend at Ocean Reef with friends that you've known practically your whole life? What a magical day this could have been. Now, they were there at that sandbar for almost 3 hours. And the evidence is going to suggest that perhaps Mr. Pino overstayed the time that he wanted to be there. Why? Because when he starts getting the girls to rendezvous back onto his boat, 12, 17-year-olds plus his wife and him, he leaves the area here. Where they had been, and begins to traverse back down south, where he's going to traverse through Cutter Bank Channel to get back to Ocean Reef. Why? I told you about him having a party planned. This was the invoice for that party. It was to go from 9 p.m. to 11 p.m. It was going to be a custom buffet with salads, mini burgers, chicken, all of this kind of stuff. It was an outdoor venue that was going to be catered, and it was supposed to be a great time. But my goodness, yes, 12 teenage girls that are going to need to get showered, get their hair dried, get ready to go out for this event. Now, these girls were staying in a home that the Pinos had rented for that weekend. It wasn't like some gigantic mansion. As he's heading back toward Ocean Reef, he is going faster than when he was going up there. And when he was going up to the sandbar, we know from the GPS that he was kind of circumnavigating things like this. What we know from the GPS is that when he was coming back, he was doing a lot more straight through traveling. Now, the waterways, of course, are different from the roadways. We don't have speed limit signs in the same way on the water that we have on land. But there are rules that are to be followed. Even if there is no speed limit, one of the rules is that you must operate your vessel at a safe speed for the conditions. I already talked with you about the fact that there's a rule you are to operate your vessel on the starboard or right-hand side of the channel. George Pino operated his boat on a plane, which means that it's basically just skimming the surface of the water. He's gotten so fast that the boat is just traveling on top of the water. He's operating it on the port side, meaning the left side of the channel, not the right. And as he was going through that channel, heading back to Ocean Reef, just as he had his GPS on the way up, his GPS was on the way back. The GPS on his boat tracked his every move, his direction, when he changed direction, and it tracked his speed. The GPS on his boat was like a silent witness, watching and recording his every move. So You'll learn in this trial a little bit about how GPS works. For now, I will just leave you with this. Properly interpreting it can tell you moment by moment where the boat is going, how fast it's going, and how long goes by from one time when you change direction to the next time you change direction. So what winds up on the way to, yes, this is the GPS data that we have from the defendant heading, before he leaves, heading up this way to where Elliott Key is. And then you see these little like track mark, these little blue dots. Those are track marks. Those show every time the boat is being changed in direction. This is where he originally gets to at Billy's Point, but it's too shallow for one of his friend's boats to be there. So he heads up further north until they get right here. Then, and he gets there at about 3:47. From there, the GPS is turned off because the boat's anchored. What do you need your GPS for? At 6:18, the GPS is fired back up again. And we know track mark, he's navigating his way through here. And now look at what we see here. Straight lines, track mark, straight line, track mark, straight line. A very different driving pattern to get back than to get up there. So what do we know happens as once he starts entering into Cutter Bank? We know that he is going straight down this way, right? There's a channel marker here, channel marker 14. Here is channel marker 15. This would be the channel, and he's hugging the left side of that channel. And what we know is that before he gets to channel marker 15, right, at 6:37 and 28 seconds, he has his last track mark. That's the last time he changed direction. And what did he do? He tried to avoid channel marker 15 right here, but it was too late. Let me back up a bit. So here we see the defendant's track lines heading up, and here he is coming back on the return track. And we see one track point here and one track point here, which is less than 30 feet away from where that channel marker is. And what we know is that when he leaves this track mark, he was going 43 miles per hour. This last track mark, right before he hits the channel marker, he's going 47 miles an hour. He's literally accelerating through that channel. What is this? All these little track marks here? This is after his boat crashes into the channel marker. Because he was not wearing a thing called a kill switch, which you attach like to your waistline or something, so that if you get ejected from the boat, it kills the engines so that nobody will get chopped up by a propeller. Thankfully, even though he was not wearing a kill switch, which is why we see the boat is still moving because the engines are still running. Thank goodness nobody got chopped up in this case. To give you an idea of what it looks like for a 29-foot center console vessel to smash into a steel pole as fast as George Pino did, what you'll learn in this case is that we all have to talk like sailors a little bit in this case, right? So starboard and port, right and left. So this is the starboard side of his boat. And what happened is he initially hits with the front of the vessel right here called the bow. Boats, unlike cars, are not made of metal. They're made of fiberglass, which is plastic. And unlike metal that crunches and crashes, plastic flexes. So when he first hits that, the boat flexes. And what winds up happening is the boat rides up on the channel marker and literally is gouged open by the board that's at the top of that channel marker that says 15. And it rips the boat right open. When it comes to the other side of the channel marker, it's taking on water like crazy through this gigantic, gash mark in the boat. And as the boat is in the water and taking on all this water, it flips upside down. This is a picture of the vessel at final rest. You can see that huge gaping hole in the boat. Now, in the aftermath of this crash, it was chaos. The only person who was keeping a lookout for this vessel was the defendant. His wife, who was seated next to him in the center console, she was on her phone. The kids were all thinking that George Pino's going to get them home safely. They're not keeping lookout for danger. This all came as a shock to them. It should not have been a shock to the defendant because the evidence will show that 9 seconds prior to impact, George Pino changed direction just 5 degrees to port, just a little nudge to the left side of that channel. And when he did that, he was on a complete collision course, an absolute collision course with where channel marker 15 is. For 9 seconds, from this moment, when you're out on the water, as you'll learn in this case, you can see that channel marker ahead of you if you're looking. For 9 seconds, he never changes direction. He smashes right into it. And to give you an idea of how long that is, that's how long he was on a collision course with that gigantic steel pole. After the boat hits the channel marker, some girls are ejected from it, some girls jump off the boat, but there are now 14 people in that water. One by one, the girls who were not too badly injured try to seek out and find their friends. The defendant's wife, same. The defendant, though, he just kind of holds on to the front of his boat, which is now upside down, and the anchor of his boat has become the canopy, because the canopy of his boat is now on the bottom of Biscayne Bay. One by one, they're trying to account for all the girls. Where's Ceci? Where's Kati? Where's Mia? Where's Carol? Where? All these girls. And eventually, through all that chaos, there are some that are not conscious. There's some that are borderline conscious. Everybody is accounted for, but one. They're looking and looking. Where's Lucy? Where's Lucy? Somebody yells to the defendant, still holding on to his boat. Look under the boat. Maybe she's trapped under there. She was. The injuries she sustained were not great injuries, but she didn't die from those injuries. She died because she drowned. She was underwater, unconscious, and she drowned. When Lucy's body is found, she's brought up onto a Good Samaritan boat. Because this was Labor Day weekend, there was a fair amount of vessel traffic out there. And without too much time going by one, Good Samaritans came and tried to help get all these people out of the water. When Lucy was brought on board, there were people on that little boat who started performing CPR on her. People start calling the police for fire rescue, for help. Now, it's tricky to give your exact location when you're on the water if you don't know how to give your coordinates, because it's not like you can look up and say, oh, I'm at the intersection of 12th Avenue and 14th Street. So sometimes it takes a little bit longer for first responders to get to the scene of a boat crash. Well, when the first responders get there, they know that Lucy is in dire shape. You'll hear that one officer, when he approaches, he's seeing a helicopter from above, which is trying to lower a paramedic onto the boat that Lucy's on. But the problem is the boat Lucy's on isn't very large, and the wash from the propellers is starting to make that boat spin. So he has to nudge his police boat up against the boat Lucy's on, and another officer has to do the same to keep the boat steady enough that it will be safe for the paramedic to come onto the boat. Once the paramedic is on the boat, load Lucy up onto a backboard, and they transfer her to another boat. And then that boat takes off for this location here, Elliott Key, which is a long, really narrow island. And right about in the middle of it, there's a ranger station. And that's a place where it would be safe for a helicopter to land to then take Lucy to a hospital as fast as possible. Well, all along the way that they are trying to get her to Elliott Key, the officers are taking turns doing CPR on Lucy. The fire rescue guy is trying to intubate her. They're trying to get her heart pumping so that blood and oxygen will get to her brain. As you can imagine, a scene like this is pretty chaotic. The man who was tasked with the responsibility of managing this chaos is named William Thompson. He was at the time an investigator with the Florida Fish and Wildlife Conservation Commission, better known as FWC. Since the time of this crash, he's been promoted and he is now a lieutenant. Lieutenant Thompson was responsible for coordinating with all the different responders that came to this scene. Officers from the Miami-Dade Sheriff's Marine Patrol Unit. There were Coast Guard officials that came to the scene. There was other fire rescue units that came to the scene. There's the management of finding out who's injured, what's the level of injuries, conducting that kind of triage, figuring out what hospitals different people are going to go to. And beyond that, he also needed to find out what happened. How did this happen? The girls really couldn't give him any information. They're not paying attention, because what you'll learn is that on the bow of the defendant's boat,
they were all drunk.
up in this area here, there was a girl sitting on every seat available. The defendant and his wife were sitting at the center console, and there were two girls that were seated in the back. These girls up front, their backs are to what's coming up ahead of them, and they're hanging out with each other. So they can't really tell what happened. And the defendant's wife was playing on her cell phone. So the only person that Lieutenant Thompson could try to find out how did this crash happen from was the defendant. Now, the defendant himself, for sure, got banged up. He had a cut to his head, a cut to his elbow. I think some of his teeth were, knocked around a bit. But overall, he was okay. He'd been checked out by police officers, fire rescue. He was ultimately transported to Elliott Key, which is where they brought all the other girls that were not tremendously injured. And there, Lieutenant Thompson winds up trying to find out from the defendant what happened. He could find out what happened from the defendant and from the GPS. And like I told you, the GPS told the truth, but he did not. When Lieutenant Thompson is interacting with the defendant, he's wearing what's known as a BWC, a body-worn camera. It's right on his chest. And while he's talking with the defendant at a picnic table that's there, the defendant is seated across from him. Now, you can't really see his face because it's like from chest to chest level, right? But you can hear what's being said. You'll hear the way that Lieutenant Thompson was speaking to the defendant in a calm way, just trying to find out what happened. Because at that point in time, there's no indication that this is a criminal case. They just need to figure out what the heck happened. So as they start talking, the defendant starts explaining himself. But the way he does it was an abdication of his responsibility and accountability, because the evidence in this case is going to show that what he said happened did not happen. What he did to avoid responsibility and accountability is he told this story to Lieutenant Thompson that there was this other vessel that had thrown a big wake in his way. And to keep his passengers safe, he had to try to attack through the wake, like taking evasive action. But we know from the GPS, which Lieutenant Thompson didn't have at that moment, he was on a straight course. I showed you. It was for 9 seconds straight ahead. There was no other boat. He made this up because he didn't want to be blamed for what was clearly his fault. So when Lieutenant Thompson asks, how did the crash happen? The defendant tells this story about what the evidence is going to suggest is a phantom boat. Now, clearly, nobody's going to be fully in charge of their rational faculties after a horrific event like this, whether it's your fault or not. This is a really stressful thing for anybody to go through. And he was injured. But he was alert. He was able to walk around. He was able to be responsive to questions. When the defendant told this story of the phantom vessel, he then was asked, would you give a written statement about what happened? This is what he wrote. Going back to ORC, Ocean Reef Club, through channel, pass boat on left side of my boat, veer to the right to avoid big waves. Coming back into the wave, I lost control of steering wheel as boat was going through the big waves. I was ejected from the boat. That's what he said happened. He said it in more detail orally to Lieutenant Thompson, but that's what he wrote. And even when the GPS proved that he was wrong, he doubled down on the things he said to Lieutenant Thompson. Because in the aftermath of this crash, there was a lawsuit against the defendant. And you'll learn that in civil lawsuits, one of the things that happens is a civil attorney may say to the person that they're suing, tell us about how this crash happened. And that kind of a document is called an interrogatory. And when you answer an interrogatory, your answer has to be under oath through the penalties of perjury. And when he was asked in this interrogatory, how did this crash happen? You know what he said? What I said to Lieutenant Thompson, that's how the crash happened. How did the police wind up getting this GPS data? Well, in an effort to appear cooperative with the police, the defendant signs a form giving them consent to go on his boat and take from it the SIMRAD, that's the brand name of the chart plotter devices or the multifunctioning displays that he has. It's not completely unlike CarPlay, if anybody uses their Apple phone with their car, where you can scroll through different maps, charts, things like that. The defendant gives permission for that. And those SIMRAD navigational devices are then brought to a man who is, number one, a former FWC officer. Number two, is currently a lieutenant with the town of Palm Beach Police Department as an internal affairs supervisor. But also number three is a maritime expert who testifies regularly in the field of safe navigation, safe boating requirements, and also in how to download and interpret GPS data. His name is Paul Albert, and you will hear from him about how GPS works, how he was able to extract GPS data from the defendant's boat, even after it had been upside down and underwater until they could salvage it and bring it back to shore. He will tell you unequivocally, the defendant's boat took no evasive action to avoid striking that channel marker. There was no other boat in that vicinity. The defendant said that there was another boat, which is clearly disproven. He also told Lieutenant Thompson that he had 2 beers while he was out at that sandbar. Now, it would not be practical for you all as jurors to go out to the scene of this vessel crash and feel for yourself what it's like to go 47 miles an hour through that narrow channel on the wrong side of it. So Lieutenant Thompson and Mr. Albert did the best that they could to try to recreate it for any jurors that might be on this panel, whether you have experience boating or not. What they did was, using buoys and GPS points, they dropped one buoy in the Cutter Bank Channel where the second to last track point is, and one right before the last track mark, which is less than 30 feet away from where that channel marker is. They then had Lieutenant Thompson take his police vessel, which, like the defendant's, is 29 feet, has a center console, and has 2 300 horsepower engines. And what he did was he then began coming through the channel, and by the time he got to where that second to last track mark is, he was going 43 miles an hour. He then continues to accelerate his vessel until he's at 47 miles an hour, and at the last second, swerves to avoid hitting the channel marker. To give you an idea of what that's like, we had a veteran crime scene detective with the sheriff's office come out on a Marine Patrol boat and launch a drone that then could film the boat as Lieutenant Thompson piloted it through the channel. In addition, a GoPro camera was affixed to the front of Lieutenant Thompson's boat so that jurors could get an eye view of what you could see if you're looking and when you can see that channel marker up ahead. In addition, a GoPro camera was attached to the actual channel marker so that you could see that same approach as Lieutenant Thompson comes right up to it and avoids hitting it at the last second. Now, lest you think that the police did all of this without concerns for safety, you will learn that during this exercise, there were marked police boats on the north and south end of the channel to make sure no vessels were going to be in that area. Plus, we had the Marine Patrol boat that the detective had launched the drone from. Plus, as Lieutenant Thompson was going through this channel, he had his police lights activated. In addition to that, everyone that was on board his vessel for this exercise was wearing a life jacket, or what's called a PFD, a personal flotation device. When you see this footage, you will realize that traveling 45 miles an hour through waters, even when they're calm, is nothing like going 45 miles an hour in a car. Boats are not encased in steel like cars are. They're not equipped with anti-lock brakes. They don't have seat belts or airbags. One mistake on the water can cause absolute catastrophe. Oh, and also, before this exercise, Lieutenant Thompson did not consume 2 beers. Now, although we can't take you to the scene of where this horrible crash happened for safety reasons, because you can't predict what the weather's going to be like during a trial, you will be taken on a field trip to the Florida Fish and Wildlife office, where they have a yard that they can store vessels that have been involved in crashes. And you will see with your own eyes this very boat. You will see the horrific damage, and you will be able to see for yourselves that anyone at the helm of that vessel, looking straight ahead, would easily be able to see a huge steel channel marker with a day-glow green board at the top of it. There's no evidence to conclusively prove that George Pino
Okay, we're back to the Wisconsin trial where the guy is representing himself. I don't know how I feel about the boat trial. I mean, I guess I do want to see the reenactment of the boat situation, but I mean, he's being criminally charged. I guess I just kind of 50-50 on it. I mean, the parents let their kids go with these parents. There were 12 kids and 2 adults. That's not a good ratio, honestly, if you're going to be out on the water. I wouldn't think. I don't know. And I'm pretty sure all the parents knew there was alcohol. 2 adults, 12 teenage girls. There's like, I mean, it doesn't look like a very big boat, 29 feet. I don't know. I feel like that's, I mean, who's responsible? I don't know. I just feel like you could do a wrongful death suit, get some money, and move on about your beeswax. It's a horrible, horrible thing that happened. But should the guy do prison time? I don't know. I think that's, I don't know. I just don't know how I feel about that. I guess it's no different than somebody drunk driving. I wouldn't have let my daughter go, but that's just old school parenting, I guess. I don't know. I mean, we went out on the river and stuff. I didn't go out on the river, but I mean, I know people that went out on the river and stuff when I was where I was growing up. People did that stuff all the time. So it's just, that was just normal. I don't know about the criminal charges though. That's just kind of, I mean, I guess, I mean, it's just kind of, I mean, aren't the girls' parents kind of responsible too? They let their daughters go. So
Your Honor, I'm really not prepared for this. I protest these proceedings.
Okay, that's noted. We will bring the jury in when they are ready.
I mean, again, like when you let your go to somebody else's house or to school or something like that, like, but still, it's still your child. I don't know. I just don't know how I feel about the whole, like that guy being criminally charged. I'm sure they sued him in a wrongful death suit and they got a lot of money from him already, but I don't know. She hasn't mentioned that he did a breathalyzer. So I don't know if he did a breathalyzer and he was drunk or not. Yeah, I feel like, where are the other parents? Where are the other chaperones? I'm not really sure how I feel about it. There would be more adults. I'm just picturing like back home in Alabama, there are probably more adults than kids. If I'm thinking about like our friends, there'd be more adults than kids because we'd get rowdy. Yeah, I don't know. I just think, and I see her parents in the gallery, and there's obviously, I mean, they lost their daughter, so they're obviously very upset. It's been 4 years, but what the heck? Yeah, right. So, I mean, it was all girls. Yeah, I think people are just too lax with their kids. I mean, even with uh my son, I thought I was being like extra strict and whatever, but clearly not. He was sneaking out of the house and I didn't even realize it.
Oh man, he's crying.
Childhood. These were generational friendships.
Hold on, what did I miss? What did we miss? We missed something. Oh,
Ms. Rose, come all the way up to the witness stand right here. When you get up to the chair, please stay standing and raise your right hand to be sworn in by my clerk.
Sorry. Please raise your right hand. Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may have a seat, ma'am.
I don't know what did.
I'm going to have you start by pulling yourself up nice and close to that microphone. That black bar with the red dot is our microphone. Get situated nice and close to that and start by stating your name, spelling both your first and your last name.
My name is Glenda Rose, Glenda, and my last name is Rose.
Attorney Thompson?
Thank you. Ms. Rose, where do you currently reside?
At 1512 East North Street.
Is that located in the city and county of Waukesha, state of Wisconsin?
Yes.
And how long have you lived at that location?
36 years.
Okay. And is that located right at the bottom of the hill here from the courthouse at the intersection of Moreland and North?
Correct.
And is that an apartment building or a condo building or something else?
16-unit apartment building.
Are there any common stairways in this building?
Yes.
How many?
The two side stairways.
Okay, and is there a parking structure at all on the property?
Underground parking, yes.
Does each resident have access to that underground parking structure?
Yes.
Is each resident assigned or given a parking stall?
Yes.
In that garage, the underground garage, are there also any storage units associated with each apartment unit's parking stall?
Yes.
Can you describe for me what those look like?
It's a storage bin above where the people park their cars.
And is it created out of wooden slats or
Yes.
something else?
Yes, I should have said that.
No, that's okay. You can't be expected to read my mind. Now, having lived in this apartment building for 36 years, is it fair to say that you are able to maintain some familiarity with the residents who live there?
Yes.
And over 36 years, you've seen residents come live there and then subsequently move out. Is that fair to say?
Yes.
Do you have any particular role or responsibilities at the property at 1512 East North?
As things break down, I'm notified and then I contact Jeff, the owner.
So is it fair to say then you're kind of the middle person between the residents and the property owner?
Exactly.
Okay.
Just
And
one moment. Ms. Rose, I know you might be nervous. That's fine.
It's an understatement. Sorry.
Just want to make sure that because my court reporter sitting right in front of you has to take down everything that's said, it's important that you wait for the entire question to be asked before you begin your answer. Just that way people aren't talking over each other, okay?
Sorry.
Thank you. Attorney Thompson, you may continue.
thank you. Is there an official on-site manager position with the apartment building? Or is that something you have kind of taken upon yourself over the years to assist with?
That's me.
And how long have you been in that managerial role?
10 years.
Madam Clerk, if you could please put the screen on just in front of the witness for now. And Ms. Rose, while this is loading, I'm showing you a few exhibits and I'm going to go through each one and then I'll have some questions for you about them when we're finished, okay?
Yes.
Okay, here's the next one. Okay,
Could you show Exhibit 1 again? I don't know that the screen was up by that time.
it's not on Mr. Lychwick's screen either. Okay, now I can see it's on Mr. Lychwick's screen at council table. I'll go through them one more time just so everyone can see them. Okay, Ms. Rose, having viewed each of those 4 documents, are you familiar with what those documents show?
Yes.
Is it fair to say that you did not take these photos or create that floor diagram?
Correct.
But is it a fair and accurate depiction of where the building is located and what the property looks like?
Yes.
I would move exhibits 1, 2, 3, and 19 into evidence and ask to publish to the jury.
First, as to admission of the exhibits, Mr. Lychwick, do you have any objection to those coming into evidence?
No.
All right, those exhibits are received. And Mr. Lychwick, do you have any objection to those exhibits being used with the jury?
No.
All right, the state may use the exhibits with the jury.
Now, looking at what is marked as State's Exhibit 1, Ms. Rose, are you familiar with the application of Google Maps?
Yes.
Have you seen that used or used it yourself in the past?
Yes.
And what does Exhibit 1 show us then?
The building.
At 1512 East North?
Correct.
And at the intersection here at Moreland and North?
Yes.
Then moving to Exhibit 2. Are you familiar with a former tenant at this building named Carlos Maldonado?
Yes.
Do you know how long Carlos lived there?
I want to say 2 years.
And did you know Mr. Maldonado? And by that, that's kind of a vague question, so I'll rephrase that. How well, if at all, did you know Mr. Maldonado over the time that he lived there?
In passing in the halls, in the laundry room, saying hello and stuff like that.
Okay.
Mm-hmm.
And do you know a resident of 1512 East North by the name of Kevin Lychwick?
Yes.
Did you know him by any other first name?
Conrad. Oh,
Well,
sorry.
No, that's okay. Exhibit 2 then, can you describe for me what you see here?
The layout of the apartments.
Okay, and so Carlos lived in between both Mr. Lychwick and you, is that fair to say?
Correct.
Now, when you are looking outside your windows, what part of the property do you see?
The back hill.
Looking then at exhibit number 19, do you recognize this picture then?
It's the back hill.
Okay, and if we're looking where my cursor is, it looks like a little hand right now, if you can see that. Did you and Mr. Maldonado and Mr. Lychwick live on the first or second floor of this apartment building?
Second floor.
So if you are watching the cursor go back and forth on exhibit 19, is that where your apartments would be in relation to this back hill?
Yes.
Now, I had just asked you if you knew an individual or a resident named Kevin Lychwick, and he also went by a different first name. Which name did you call him?
Conrad.
Is there a particular reason why you called him Conrad versus Kevin?
He has to be called Conrad.
Was there ever a time when you called Mr. Lychwick by Kevin and he demanded that you call him by Conrad?
Yes.
Can you describe for me the tone in which he wanted you or told you he wanted you to call him that name?
It was just very abrupt and said, call me Conrad.
I know you talked about how you were more of acquaintances with Mr. Maldonado and you saw each other in passing and you would say hi. Did you have any kind of relationship with Mr. Lychwick?
No.
Did you ever say hi to him in the hallways?
I would always say hi.
Did he ever reply back to you?
Sure.
Did you ever have conversations or interactions with him in the laundry room like you did with Mr. Maldonado?
Not very often.
Okay. When you did see Mr. Lychwick in passing, was there ever any thought on your part that he wanted to engage in conversation with you?
No.
Did you feel ever in passing with him that you wanted to engage in a conversation with him?
No.
Do you know how long Mr. Lychwick has lived in this apartment building?
I think it was 5 years.
Going back then to the reason you're here today, and I'd like to direct your attention to October 30th of 2024. On that date, were you at the residence at 1512 East North?
Yes.
And in the afternoon hours, did you get a phone call that led you to go outside of the building?
I did.
Can you describe for me what happened when you got that phone call?
Nathan called, actually it was Terry, called and said Nathan found a body outside.
And from there, what did you do?
I went downstairs to go take a look.
And when you got outside, did you go through that back stairwell that we talked about, or did you go through the underground garage or something else?
The back stairwell.
And where did you go from there?
Across the parking lot to where Nathan was standing.
In looking at exhibit number 1, can you see the driveway off of East North Street leading to your apartment building?
Yes.
Actually, that screen in front of you is a touch screen. If you wouldn't mind just kind of drawing a line over that driveway for me.
That's the driveway.
Okay. Now, when you exit out of the stairwell and you go to where you said Nathan was, can you circle for me on exhibit 1 the approximate area in which you saw Nathan? When you go up the driveway, and we can see on exhibit 1, it's slightly curved. Is there a retaining wall to the right-hand side when you're driving into the underground parking structure?
Yes.
And above that retaining wall, is there a path?
I don't know if I'd call it a path.
What would you call it, please?
Broken down trees and kind of a walkway, you know, I guess a path, yeah.
No, that's okay. If you call it something different, I don't want to put words in your mouth.
I mean, it's I guess a path.
Okay.
It's a walkway.
And we can see on exhibit 1, this property is surrounded by trees where it's not surrounded by roadways. Is that fair to say?
Yes.
And those woods, are they thick with vegetation and brush and bushes and trees, or is it more of a stark type of wooded area?
Correct, yes.
And when you go on top of that hill that we observed in exhibit 3,
Well, this boat trial is
exhibit 19.
Before we change off of exhibit 1, if you don't intend for the witness to make any further markings on it, let's capture that with the witness's markings. She's drawn a green line on the driveway and a green circle to signify where she met up with Nathan. We'll capture this. This will be 1A.
Thank you, Judge. Now, Ms. Rose, going back to Exhibit 19, we can see the upward slope of this hill. On top of that hill area, is there also still trees and brush and vegetation up there as well?
Yes.
Is there a slight clearing at the top of that hill where some of the residents might do some gardening?
Yes.
This back area here in Exhibit 19, is that open to all of the residents that live at 1512 East North?
Yes.
Okay. Now, you come outside, you go to where Nathan is standing, and what do you see?
A pile of twigs and a tarp, and then it was opened where I could see a body.
Objection. Not facts of this case. The body was found at the bottom of the hill, not the bottom of the hill, but rather at the end of the driveway.
All right, the objection is overruled. The witness can testify about what she saw. If there is additional evidence through another witness, that may be presented as well. But the answer was responsive, so it's overruled. You may continue.
Now, Ms. Rose, I'm going to show you what you previously looked at and what has been marked as State's Exhibit number 3. What does Exhibit 3 show?
Pretty much what I found.
Pretty much what you found, or what you found, or
What I
something
found,
else?
Yeah. Yeah.
One at a time, please. Can you finish your question?
Yes. Exhibit 3, does that show exactly what you found when you walked out of the garage? I'm sorry, the stairwell, or something else?
Something else.
Okay, then what does Exhibit 3 show?
Well, that's not how I saw it at first.
How did you see it then?
It was opened up. Nathan had opened it up to find a body.
Okay, now, is there, on the opposite side, is that where you saw that it had been opened, or something else?
Possibly, yes. Yeah.
Okay,
Mhm.
now, when you walked up to it, you said you saw a body. What specifically did you see?
I saw the middle of a body and legs and knees and shoes.
Thank you, Madam Clerk. I'm finished with the screen. You indicated that once you were out there and you saw this pile, you saw what looked like a body. Did anyone call police?
Jeff, the owner, did.
Okay. And did you stay with this pile until police arrived?
Yes.
While you were standing with that pile, did anybody else or any other residents, or did you touch that pile or start taking off those branches?
No.
Now, you indicated you were familiar with a resident named Carlos Maldonado, correct?
Yes.
And with this discovery being on April 30th of 2024, when was the last time you remember seeing Carlos Maldonado?
Do you mean October 30th, 2024? I believe you said April 30th.
I'm sorry, October 30th of 2024. When was the last time you saw Carlos Maldonado?
April 14th.
Of 2024?
Correct.
And since that date, then, you had not seen him at all around the property?
Not at all.
Was that unusual?
Yes.
What did you see Mr. Maldonado doing on April 14th?
He was in the garage cutting up some wood.
And then after that date, he just disappeared?
Yes.
Did you ever have any phone contact with him?
I tried.
Did he ever answer?
No.
Was his apartment ever cleared out?
Yes, but
Okay.
not for a while.
Okay. Now, I'll ask a more specific question then. So From April 14th to October 30th of 2024, had any of Mr. Maldonado's family members come to the apartment building looking for him?
Yes,
Did you allow any of his family members into his apartment?
yes,
Did you go inside with those family members or did you stay outside?
I went in.
And when you went in with the family members, was the apartment still full of items or was it completely bare?
Full.
Was one of the family members that you allowed into the apartment to Lisa Maldonado?
Yes,
Had you been sliding Mr. Maldonado's mail under the door or anything, or
yes,
you had been?
Mhm.
Okay.
That was a yes.
yes.
Thank you.
Sorry.
Miss Rose, you indicated that you saw Mr. Maldonado cutting wood the morning of April 14th, correct?
Yes,
Was there a mess of sawdust left behind in that area?
yes,
Did you clean that up?
yes.
Do you know about how long after April 14th you realized that pile was still there and you took it upon yourself to clean it up?
Couple weeks.
I do not have any other further questions for this witness. Thank you.
All right, Mr. Lychwick, cross-examination.
Yes, please. Glenda, you simply could not have found the remains of poor Mr. Carlos at the top of the hill there because he was not found there. He was found at the bottom of the driveway.
I'm
Mr. Lychwick,
going-
you have to, hang on, everyone. Mr. Lychwick, you have to ask a question, okay? So you can ask her to confirm her statement about where she found the body, but this is not a time to testify about what you think the other facts are. So go ahead and ask a question if you would like.
Where was Mr. Maldonado laying, Glenda?
Halfway down the hill on the right-hand side.
Where was he in relation to the driveway?
Halfway down. Almost to the bottom of the driveway.
Thank you. So he was found almost at the bottom of the driveway, across the wood from the edge of the driveway where it meets the road.
Is that correct?
Asking
The
me?
entrance of the driveway where it meets the road, Glenda.
It was not close to the road. I mean, not as close to the road as what you're saying. In the middle of the hill, if you halfway down.
But the hill is not to be confused with the hill that is perpendicular to the stairs that you took to get into the driveway when you left your apartment. Is that right?
Right.
So we are talking about then at the end of the driveway, that area. Are we not?
No.
How can that not be? Because the
Because the end
driveway,
of the driveway is here and the body was up here. The end of the driveway is the end of the driveway. This
Can I
was the
please
middle
have
of
the
the hill.
diagram?
Hang on. Okay, finish your answer. Are you finished?
I think so.
Okay, Mr. Lychwick, what were you saying?
can I please have the diagram of the property again?
Sure. Attorney Thompson, can you put up exhibit number 1, please?
Yes, I will.
Now, Glenda, I want you to take a look, please. If you look where East North Street begins and the driveway ends, Mr. Maldonado was found not too far up in the area, still at the edge of the driveway. Not too far from the edge of the driveway, I would say. He wasn't found up on the hill that you could see from your window.
Mr. Lychwick, again, I remind you on cross-examination, you need to ask the witness questions, not testify on your own.
I'm asking you, Glenda. Was Mr. Maldonado found more towards the edge of the driveway there than where you could see out of your window at that other hill near the cement stairs that go up the other staircase, the north staircase that is on the other side of our building there, the one that you came down to meet Nathan?
I didn't get the question.
Okay, hang on. You can repeat the question. Just try to ask simple questions, Mr. Lychwick. Straightforward questions.
I'm trying, Your Honor. Glenda,
She said I didn't get the question.
Mr. Maldonado was not found within eyesight of your apartment window. Is that correct?
Correct.
So, if we go back down to the end of the driveway, he was found closer to that area than he was to the top of the hill that you can see from your apartment window. Is that correct?
Correct.
Thank you. I have no further questions of this witness.
Thank you. Any redirect?
No.
All right, Ms. Rose, you are excused. Thank you. You may step down.
The state calls specialist Nichelle Nelson.
I'm hoping this trial is going to go pretty quickly because he's defending himself. So. Yeah, I'm always cautious about covering these kind of trials.
All right, ma'am, you can come all the way up to the
They
witness
defend
stand.
themselves. It is a frickin'
When you get up to the chair, please remain standing
Like
and raise your right hand to be sworn in by our clerk.
like I only
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth,
because
and
they're
nothing but
just
the
so
truth, so help you God.
dumb.
I do.
You may have a seat. That black bar with the red dot in front of you is
This
our microphone.
millionaire,
Get
the
yourself
boat trial,
situated nice and close
actually-
to that. And start by stating your name, spelling your first name and last name for the record.
Quite dramatic.
Nichelle, Nichelle, Nelson, Nelson.
They're back on the boat.
Ms. Nelson, how are you employed?
As a specialist for the City of Waukesha Police Department.
As a specialist, are you also a sworn law enforcement officer?
He's having a very hard
How
time.
long have you been a sworn law enforcement officer in the state of Wisconsin?
Currently in my 29th year.
Composure.
What is the difference between an officer or detective or a specialist, which you are?
It's a promotional process from an officer to a specialist.
And do you have a specific role as a specialist in the City of Waukesha Police Department?
Currently, I'm assigned to the forensic unit.
And what is the forensic unit responsible for?
Currently assigned to process crime scenes, in charge of our property room, fingerprints, and making sure things get sent to the criminal bureau for identification purposes.
To be a crime scene technician, do you have to go through any specialized training outside of that standard police academy that we're all used to hearing about?
Yes, additional training, including forensic or basic evidence technology schools, as well as some additional courses that we choose to, such as maybe a death investigation course or additional photography courses.
Have you been to a death investigation course?
Yes,
More than one?
I just believe I took one course.
Okay. And as a crime scene technician, do you have to do any kind of continuing education?
We do throughout our career. Sometimes we attend the State Crime Lab puts on a once a year training, and sometimes we attend that.
The death investigation training that you just spoke about, is it specifically focused on homicide investigations or something more?
It's a variety of death investigations, so not just homicide.
Okay. Now, do you have another specialty within the City of Waukesha Police Department?
I also have a canine. He's an electronic search detection canine.
And what's his name?
His name is Canine Riker.
When it comes to crime scene investigations, is it fair to say that each person or each law enforcement officer that responds to the scene has a specific duty or role assigned to them?
Yes, but I would also say that we also work in collaboration with each other.
Okay. What would be the purpose of having individual roles for each person?
We're able to divide up tasks and get things done more efficiently.
When you arrive at a scene, and let's specifically focus on a death investigation, what is one of the first things that law enforcement will do in terms of protecting the integrity of that scene?
First thing we would do is we would like to make sure the scene is secure. Make sure that nobody outside of law enforcement comes into that scene.
Is that generally where we see that yellow crime scene tape around the area of the investigation?
Correct. And then to take it one step further, we also have red tape that sometimes breaks it down even to a smaller area.
Is there an officer who is assigned to keep a log of everyone that goes in and out of a crime scene?
Yes.
Are there times where, as a crime scene technician responding to a death investigation, you may not know if the death is suspicious or not at that time?
Yes.
When you are responding to the scene as a crime scene technician, and let's say your role is to take photos of the scene, is there a methodical way in which you do that, or do you just randomly walk around and take pictures?
I generally start large and work small.
And why do we do that?
So that you can generally gather what you're focusing on so that you can see the overall
This guy
photos of what you're taking that picture of, and then generally then you can focus in on exactly what you're looking at.
In this boat trial.
And what is the importance of taking photographs at a crime scene?
It's not going away.
Once we leave, we can never get that crime scene back. So we have to see the crime scene as it was when we get there.
If you are searching, let's say, a vehicle as part of your training experience as a crime scene technician, do you just start opening doors and taking things out, or is there a different way in which you do that?
No, we would also photograph that vehicle prior to doing any search of that vehicle.
As a crime scene technician, are you ever responsible for, once photos are taken of an item on scene, placing that item into police property or inventory?
Yes.
And is there a particular way you are trained in taking items from a crime scene and placing it on property inventory?
Depending on what type of item it may be, it would go into paper or plastic. Those items would stay in my care or possession until I would place those items onto our property management system, which is Phoenix Property.
And when I say placing an item onto police property, is it just a big property room, or can you describe for me what that is?
So our logging system is that I would actually take it back to the police department. It may require additional photographs of that item close up. It then would be packaged. We then create a report, and from that report, a label gets generated and placed onto that individual item.
Does the property room at your police department at the city of Waukesha, does that allow everybody inside, or are there only particular people that have access to that room at any given time?
It has restricted access. Myself, my two partners that I work with, our clerk and our two computer forensic also have access to it, as well as our boss.
When we're talking about items located at a crime scene, do you know right away if that item has evidentiary value?
Not necessarily.
Are there times where you seize items that you might want swabs taken from?
Yes.
And when I say swabs, what would be the
definitely
purpose
live
of
in the
swabbing an
wilderness.
item?
For DNA.
We were
And
walking
are there ever
into a
times where you take
thing,
items where
and there was a snake,
you might want to process that item
snake.
for fingerprint analysis?
Yes,
a long
When
snake.
you are taking these items and when you're processing a scene, are you wearing gloves?
I can't.
Is there any
Can't do
other
it.
protective gear of that nature that you wear on scenes, or does that depend on the scene?
it depends on the scene.
This is
When you are
not
photographing a
for me.
scene, are there department issued cameras that you use?
Yes, we each have our own department issued camera.
And is there a particular way that you label each photo that you take from a scene?
Yes.
How do you do that?
Mine have my initials of NMN, and then
I'm
they're
ready
labeled
to
sequentially.
set the place on fire.
Every
But I
time you
can't
finish
do
at a
it.
scene
I-
and you go
he
back
didn't
to the
see
police
it, thank
department
God.
with any property
My
that you may
husband
have
saw it before I
packaged,
did. He was like,
do you
"Oh,
empty
look
that
at that." And
SD
I was
card
like,
on
"What?"
the camera,
And he
or
said,
is
"You
it
don't
just,
see that?
there could be multiple scenes
was
on a camera at
huge.
once?
That,
It was
that
a
would be
rat
uploaded.
snake, but it
I
was
save it on
very
my computer.
long.
I upload it into evidence.com, our retention
grabbed the
system for
dog
digital
and turned
evidence.
around
And once I know
came
that they have
straight
all been
back to the
uploaded,
house.
I then format
I
that
have not
SD
been
card.
out of this house since.
What do you mean by format that SD
It would
card?
erase
We
all the
have
images
11
from that
months and 3 weeks
particular
left to live
scene.
here.
And then it
Do it.
would start back
Can't
when
do
I go
it.
take photos the next time at
I'm
001.
ready to set
Okay,
everything
so
on
you're
my
not
window,
going to
burn
run
it
into a
down.
situation where
Burn
you
it
have
down.
photos from two different scenes mixed into one.
No.
I'd like to direct your attention, please,
can start
to
over.
October
I can start
30th
over.
of 2024. On that date, were you already on duty?
I was.
And were you called to a scene at 1512 East North Street?
I was.
What was the reason for that
This is
call?
We
bees.
got a call that there was possibly a
Hornets.
body.
There's
A
rabbits
body,
everywhere.
tarp.
Everywhere.
Okay.
Bobcats.
Sorry, go ahead and
That's okay.
finish.
Snakes.
Under some brush.
That's it.
Now, when you arrive on scene, do you immediately go to that area?
We
And the
didn't
mosquitoes.
initially approach it. We saw it from a distance.
And why did you stay back from a distance versus immediately go to that area?
We didn't know if there was possibly evidence around where the possible body was.
So that was intentional.
Correct.
Oh God, yes.
Once you arrive on
Yes,
scene,
Mark. Thanks.
what is the
Say that.
first thing
Say
that you
that.
do?
I
Yep.
spoke to one of the detectives that was there, Detective Condon, advised him that I was going to start taking photographs of the scene.
And at this point, did you know what kind of death investigation this was?
I did not.
We talked about
I've been
the
saying.
purpose of taking photos
to move
and
out.
preserving the scene the way in
Bring
which it
out
presents
where
itself to
there's
law
no
enforcement
people
at that
and
time.
they're just be left alone.
Where did you start taking photos on this property?
Be careful.
I
what
don't
you wish for.
recall if I went to the
Be
top of the
careful.
hill to start or if I started down in the parking lot.
Okay, and can you, when you start taking these photos then, do you kind of follow a path through the property so you can almost follow it through your photos?
Yes.
And you start with the overview of the property, is that correct?
Yes.
And then do you make your way back to this pile where the body was reported to have been found?
Correct.
That snake was.
Madam Clerk, can you please turn on the screen in
Not
front of the
exaggerating.
witness?
It really was. It was very long. And then it like set. Oh, I had nightmares about snakes last night.
Okay. Specialist Nelson, I am showing you a 52-page PDF packet that contains exhibits 3 through 54. Had you reviewed the photos you took of the scene at 1512 East North prior to your testimony today?
I did.
And were they a fair and accurate depiction of the photos that you took on October 30th of 2024?
They are.
I would move exhibits, well, number 3 has already been admitted. So I would move exhibits 4 through 54 into evidence. And 19 has also already been admitted.
Attorney Thompson, could you just slowly page through those exhibits, please?
Yes, starting with exhibit 3.
Go ahead, you can do it. I shouldn't have said slowly. You can moderately scroll through the pictures, please.
Now I went too fast and it's thinking.
That's fine, you can let it catch up. I think 25 was the last one that was really buffering.
Oh gosh. So the millionaire, the boat trial, they're having to take another recess because the defendant, he is still having issues. Can't be in the court. He's like so upset. He's having medical issues now. The defense hasn't even gotten through their opening statements yet because he started like he was getting so emotional and crying and all this stuff. He's squalling. So the jury.
All right, let's hold up here. This is through Exhibit 31. Attorney Thompson, are you intending to go through each of these sequentially?
I am, yes.
Okay, so Mr. Lychwick,
Have this.
so far, what was the number that it started with, Attorney Thompson?
Exhibit
now they're
3
talking about
through
possibly
54.
taking him
Okay,
out of
so
the courtroom
Mr.
and having him on
Lychwick,
a
so far
live
3 through
stream.
31, any objection
another
to
room.
those photographs being introduced into evidence?
Can't be
No,
in
not
there.
this time, Your Honor.
Then those will be admitted.
He can't be that
19 has
emotional
already
in front
been
of the jury.
admitted. And Mr. Lychwick, any objection to 3 through 31 being used to publish with the jury?
No.
All right, they may be published. Attorney Thompson, as we go through and show these exhibits, perhaps the others will buffer while we're waiting.
Oh, I hope so. Thank you.
Okay.
Okay, Madam Clerk, can you please turn on the screen for everyone, please?
For everyone.
Now, Specialist Nelson, looking at exhibit number 3,
She said everyone.
is this the possible body in a tarp that law enforcement was called to investigate?
Yes.
Exhibit number 4, tell me what exhibit 4 shows.
A different view of the same photo from farther away.
Now, I'm showing you what's previously been marked as exhibit number 1 and received. So when we compare exhibit 1, which is a Google Map
They're taking
overview of the
another medical
property,
break, and then they're
and
gonna
exhibit number
decide
4,
if he has to be in another room.
where are you standing in exhibit 4?
Because he's so emotional.
Can you show me exhibit number 4 again?
Yes.
I'm not sure if down here is the pathway from
I
the
just don't know
the
how I feel
driveway
about him being
that we walk
criminally
up, if
charged.
that's the bottom of the path.
I understand, like,
I think that is.
if they.
Okay.
So I was looking up the hill, I believe.
And as we continue going through these, I'll be asking you if you can kind of
I don't
help
know.
orient the jury as to how you're
gonna try to
walking
go
through
back and
this
forth
property.
and see.
For the record, the witness has placed a couple of green markings on exhibit number 4. Attorney Thompson, do you want to capture that as 4A?
No, I don't think that was intentional.
Okay. We'll clear it.
Moving on then to Exhibit 5, are we starting to get closer to the pile of the branches and the tarp?
Yes.
Now, Exhibit 6, obviously we don't see the blue tarp anymore. So have you switched your positioning as it relates to this pile of sticks?
Yes.
At this point, are we continuing to go further away from the driveway to the top of a hill area in the back of the building?
That would be correct.
This is just awful.
Exhibit number 7, what are we looking at here?
More towards I'd be facing towards North Street. So once again, I'm at the top of the hill looking down.
Okay, and up here where my cursor is towards the top and middle of exhibit number 7, is this the driveway of the apartment building?
Correct.
And is that maybe one of your detectives right there speaking with someone?
Yes.
Okay, now moving on to exhibit number 8, what are we seeing here?
Another view of the pile.
And why are you taking so many photos of the pile?
Just to get different angles and just in case I didn't capture something in one of my other photographs.
Moving on to exhibit number 9. What is this?
I went around the back side of the pile looking more now towards kind of like the garage of the apartment building.
Okay, and these wooden planks here, if you're following my cursor to the top left of exhibit number 9, is that kind of like a retaining wall?
Yes.
Moving on to exhibit number 10, where are we now on the property?
They had like a garden area near the top of the complex, and there was different piles of debris and branches up there. So I went up there and photographed that area as well.
Were there any other tarps or bodies under these sticks?
Did not locate any.
Okay. Exhibit number 11, what is this?
More of the debris piles near the garden area.
Exhibit number 12?
More debris in the garden area.
Exhibit 13 then, what is this?
The garden area.
Is this a pretty wide area at the top of the hill?
It is.
Where are you in this angle of exhibit number 14?
You can kind of see in the background there, the apartment complex. If I draw in here, that's the apartment. So kind of looking down towards the apartment complex.
Okay, and I do not need that to be captured.
Okay, it'll be noted that the witness placed a green X near the center of exhibit 14, but we will not capture 14A.
Thank you. Now looking at exhibit number 15, are we still at the top of the hill here?
Yes.
Have we started coming down the hill back towards the apartment building?
I believe so.
Okay, and these logs that we see, they appear to be in a square shape. Is that fair to say?
Yes.
Is this, well, actually, no, strike that. Moving on to exhibit 16, what do we see here?
I think that was the beginning of the garden area.
And exhibit 17?
Just a marker from my purposes to kind of give a demonstration or a location as to where I was photographing.
This one doesn't have a number, but it should be exhibit number 18. What are we looking at here?
The back side of the apartment complex, the hill up, and if you were to look straight ahead through that, that would be Westmoreland.
Okay. And exhibit number 19 has previously been admitted. What are we seeing here?
The back side of the apartment complex, and you can see the garage door that's open.
Okay, and that garage door leads out to the driveway that leads out to north. Is that correct?
Yes.
Okay. Now exhibit 20, what are we looking at here?
The top of the hillside.
And exhibit 21, have you continued coming further down the hill?
Yes.
And right where my cursor is at the top of these concrete stairs, is that a common doorway into the apartment building?
I believe so.
And Exhibit 22.
Just turned around from where I was and took a photo up to the top of the hill.
Now that you have completed a kind of overview of all the different areas of the property, did you then come back to the area in which the body was reportedly found?
Yes.
Okay. Now, exhibit number 23, what are we seeing here?
A close-up of the blue tarp.
As you are taking photos of this pile, did you also observe at any point black plastic sheeting?
Yes.
Okay. When you are taking these photos, have you touched any of these branches or anything yet?
Myself, along with some of the other officers or detectives, we were starting to slowly remove some of the sticks and stuff that were over the tarp.
And as you started slowly moving those sticks off, were you taking photos as you went?
Yes.
Did there come a time where you stopped taking sticks off of this pile?
Yes.
When?
I observed twine or rope, and I also observed what I thought to be shoes at one of the ends. And I took my gloved hand and tapped the bottom, and I felt a shoe. And at that point, I told Detective Condon that I felt that we had a body wrapped up.
Once you tapped and you felt what you thought was a shoe, what did you do next?
I advised Detective Condon that we needed to contact the medical examiner.
And was the medical examiner's office contacted?
Yes.
And subsequently, did an ME's office investigator and Dr. Scheel arrive on scene?
Yes.
While you were waiting for the medical examiner's office, did you continue moving the branches or unwrapping the tarp?
No.
Okay. Once the ME's office arrived on scene, what process started or continued?
We can continue to remove branches from the tarp. We worked in conjunction with them with photographs and removing items. They maintained custody of any items that they thought was relevant.
When you're looking at a scene such as this, you talked about earlier how you don't always know what items are relevant in an investigation. Is that fair to say?
It's fair to say.
And actually, no, I'll continue on. So moving on to exhibit number 24, what are we seeing here?
You can see part of a black bag as well as some rope.
Is this the area you were when you tapped what you thought was a shoe?
I couldn't be for certain with this photo.
Okay, that's fair. Moving on to exhibit number 25, are we standing further back from the pile?
Yes.
Okay. Oops. Now, exhibit number 26, have some of the branches and vegetation been moved back off of the tarp?
Yes.
Exhibit number 27, what kind of angle are we looking at here?
I'm probably standing a little bit closer and maybe a little bit more like over to get a more direct downward shot at the.
Okay, and if we look on the left side of exhibit number 27, where you see my cursor here, what part of the body was this part where my cursor is?
That would be where I thought I felt shoes, where I saw shoes.
Moving on to exhibit number 28. What are we looking at here?
An overview.
Are you seeing at this point any other ropes or twine that you talked about earlier?
Do you want me to mark?
I would love it if you could circle each twine that you see, please. Your Honor, I would ask that this be screen captured and marked as exhibit 28A.
It will reflect the 3 green circles the witness has identified. Just pause a moment until my clerk verifies that the capture is complete.
Of course.
All right, you may proceed.
Thank you. Moving on then to Exhibit 29. What, if anything, of evidentiary value do you see in this photo, Specialist Nelson?
Just some rope that's up in here.
Okay. At this point, when you start removing the branches, I do not need that screen captured.
All right, it will reflect that the witness did indicate to the right of the picture on Exhibit 29. We can clear that.
As you start removing branches, once the medical examiner's office gets there, do you find what are believed to be human bones outside of this tarp or black plastic sheeting that you referenced?
I believe so.
Do you see any of those in Exhibit 29 or not yet?
I can't tell if it's hard to say with all the debris that's in there.
Okay. Moving on to Exhibit 30. There's obviously an arm in the top right-hand corner.
Yes.
Is that yours or the medical examiner's office?
The medical examiners.
And in looking at what the ME's office employee is holding, it looks like a regular paintbrush. Is that fair to say?
Yes.
Why is she using a paintbrush? What's the purpose of that?
To cautiously remove debris.
When we're looking at Exhibit 30 then, can you start to see the outline of a foot?
Yes.
Is that the part of the body in which you are standing by, the feet?
Correct.
Okay. Exhibit number 31, what are we seeing here?
Some clothing.
Okay. Does it appear as if it's coming out of that black plastic sheeting?
Yes.
Okay. Now, Your Honor, this is where we initially stopped as the packet was still buffering. So I would move Exhibits 32 through 54 into evidence as we continue and ask to publish to the jury.
Sure, let's take the screen down, Madam Clerk, for the public. It'll remain on for counsel table and the witness. And Attorney Thompson, if you could scroll through the remaining exhibits then.
This is going much faster.
All right, you went to 53, is that right?
That one was 52. This is 53.
And this is as far as you're asking to go?
No, I still have 54.
Oh, I'm sorry.
That's okay. There we go.
The state has moved for admission of 32 through 54. Mr. Lychwick, do you have any objection to those pictures being received into evidence?
No.
They will be received. And any objection to publication of those exhibits with the jury, Mr. Lychwick?
No.
Then they will be able to be used with the jury.
Okay, now Specialist Nelson, in looking at Exhibit 32, has the medical examiner's office and yourself started the process of, or continued the process of removing all of the sticks and vegetation and debris from the tarp area?
Yes.
Do you still see the twine that you previously referenced in this photo?
Yes.
Why not just scoop up all of the vegetation and put it in a bag so you can get to the tarp and the plastic sheeting quicker?
Because there could be other evidence that we would miss in doing so.
How long were you on scene, not only taking photos, but then also processing this particular area, if you recall?
There was hours.
Moving on to Exhibit 33, are we now getting closer to the area we just saw in Exhibit 32.
Yes.
Now, in Exhibit 34, what are we looking at here?
You can start seeing some bones.
Can you circle for me on Exhibit 34 where you start seeing bones? I would ask this be screen captured and marked as Exhibit 34A, please.
It will.
Thank you. Now, when we were just talking about how you can't just scoop everything up because you might miss something, based on where these bones were, would they have possibly been in that big vegetation scoop that I just referenced?
Probably not.
You would have felt them, or?
We may have missed them.
Okay. Now moving on to Exhibit 35, what are you focusing on with this picture here?
The twine and the knot.
Do you recall which section of the body this particular piece of twine was from?
I do not.
Okay. Exhibit 36?
The knot.
Okay. Now, did there come a time at the medical examiner's office where the twine was removed from the tarp and the plastic sheeting?
Yes.
And was the twine cut at all?
I don't recall if they did. If they did, the medical examiner's office did that.
Okay. And to your knowledge, did anybody on scene untie these knots?
No.
Looking at Exhibit 37, what are we looking at here?
More of the twine and the knots.
And this appears to be, and correct me if I'm wrong, a different set of twine than what we just looked at in Exhibit 36. Is that fair?
Yes.
And Exhibit 38?
Close-up of those knots.
Exhibit 39, what are we looking at here?
A different section with the twine and a different set of knots.
Is this where the head of the body is located?
Yes.
And so the rope appears to be around, if the skull is in this circular part here, then the twine appears to be kind of towards the neck or upper chest area. Would that be fair to say?
Yes.
Exhibit 40, what are we looking at here?
Another angle of those bones.
Specialist Nelson, have you investigated crime scenes in the outdoors before in your career?
This was the first.
It was, okay. Were the tarps and the plastic sheeting sealed around the body, or were there openings?
There were some openings.
Exhibit 41, please. What are we looking at here?
Just a different angle farther down from where those bones were.
Now, in looking at Exhibit 41, if you can see my cursor, I'm kind of in the middle of Exhibit 41. Do you know what that piece of debris was?
We found cardboard.
Were there other pieces of cardboard debris near the body?
Yes.
Were those collected?
Yes.
Did we find any other pieces of cardboard debris inside the tarp or the black plastic sheeting, to your knowledge?
I don't remember if there was any inside or not.
Okay. I'm also moving a little bit to the left of the cardboard debris. And what I'm circling here, did you notice as you were processing this scene, any tape on various parts of this tarp or black plastic sheeting?
Yes.
Can you circle for me on Exhibit 41 where you see tape? I would ask, please, that this be marked as Exhibit 41A and screen captured.
It will reflect the two green circles marked by this witness.
Was the tape removed from the black sheeting that we see in Exhibit 41 on scene?
No.
Okay. Is that to, well, never mind, strike that. Moving on to Exhibit number 42, what do we see here?
Close-up of the cardboard and just that general area.
In Exhibit 43, what are we looking at in this picture?
That was some glass. I know we had found glass that night, and that could be a close-up of the glass we found.
Okay. Is this still, I mean, do we even see someone's gloved hand in the top right corner of Exhibit 43?
Yes,
So this is still the area right next to the body?
yes.
Exhibit number 44, what are we looking at here?
Another angle of the bones.
Do you also see the twine in this photograph?
Yes.
Exhibit number 45, what are we seeing here?
More of the bones uncovered.
Okay. Were all of the bones then taken or collected by the medical examiner's office and taken back to the office?
Yes.
Moving on to Exhibit 46.
Another close-up.
By this time, is it darker outside or is it getting dark?
It's getting dark.
Okay. So now that you've shifted to processing the scene at night, are there any types of lights or equipment that you use to help ensure you're still gathering everything you can from the scene?
Yeah, we got some lights up there for us to work.
Okay. Did it end up raining at all that night while you guys were out there?
I think it started, but I don't recall exactly.
Okay. Moving on to Exhibit number 47. What are we looking at here?
Just another close-up showing some of the cardboard.
Do you see any tape at all?
Yes.
Do you also see 2 sections of twine?
Yes.
Exhibit 48 then?
Twine and some more cardboard.
And at this point, has all of the brush and sticks and debris been removed from the body?
Yes.
And now we are left with the tarp and the black plastic sheeting?
Yes.
Exhibit number 49, what is this?
Just another close-up of the twine.
What is Exhibit 50?
I believe it was a close-up of one of the arms or the hands.
What is Exhibit 51?
More close-up of some of the bones that were outside the bag.
Exhibit number 52, what are we looking at here?
A photo of what the ground looked like once everything was removed.
And so you talked about how the medical examiner's office and yourself did not open up the tarp or the black plastic sheeting. Is that correct?
Correct.
Now, why take a picture of what is underneath the tarp and that sheeting?
Just to show what was left afterwards.
And in addition to showing what was left, did this scene continue to be processed, or once you remove the body, you just walk away?
No, we continued to dig through.
Why?
In case there was items that we may have missed.
In this particular scene, were there any bugs collected?
The medical examiner did take bugs.
Okay, that was the medical examiner's job then. Is there anything else that, besides taking these photos, that you collected at this very particular spot with the body?
The medical examiner pretty much took everything.
Okay.
That night.
Okay. Moving on to Exhibit 53 then. Is this still the same area?
Yes.
And Exhibit 54?
Just another photograph of that same area.
Okay. And the top layer of the ground that was right underneath the tarp, was that debris also collected by the medical examiner's office for examination?
Yes.
Okay. Now, did you attend the autopsy of these remains that we recovered in the woods at 1512 East North.
Yes,
And did that occur on November 1st of 2024?
yes.
Why do you go to an autopsy?
To collect additional items for evidence.
Does the medical examiner's office have property inventory like police do?
They, similar, but not necessarily, I wouldn't want to say like as detailed, but they have a sheet that they do give us of items that they have.
At the start of an autopsy, is there a piece of paper that is kind of like an inventory list of all items recovered from the remains by the medical examiner's office?
Yes,
And at the conclusion of the autopsy, is it yourself or whatever other law enforcement officer is present for the autopsy, knowledge that you are taking the items that the medical examiner's office is not keeping?
yes.
And in this case, do you recall taking items with you once the autopsy was complete?
I don't think I took them that day just because some of the items needed to dry. But yes, I did take custody of some of the items from the autopsy.
And then once you take custody of those items, then you go back to the police department that we talked about earlier and put everything on property inventory for subsequent processing.
Yes,
And by subsequent processing is one of those potentials to send evidence to the Wisconsin State Crime Lab for analysis.
yes,
And are there different specialized fields within the crime lab that can assist in analyzing the various pieces of evidence?
yes.
We talked a little bit about vegetation and debris that we found on scene. During the autopsy, were there particular items of vegetation that were of significance to you?
There was some, yes.
Okay. Now, those items, those particular landscape items, if you will, when you collected those, did the medical examiner's office suggest a agency who might be able to assist in the identification of those items of landscaping?
The medical examiner did not, but the state crime lab did.
Thank you for correcting me. So why did you ask the crime lab for that information and they offered it, or how did that work?
We have a pretty good working relationship with the crime lab, and through conversation of this case, they actually recommended a gentleman that works in vegetation.
Okay. Was that individual an employee of the U.S. Department of Agriculture?
Yes.
Madam Clerk, can you please turn on the screen just in front of the witness, and I will be showing you what's marked as State's Exhibits 55 through 57. Okay. Now, first showing you 55.
Okay.
And 56 and 57. Did you take these photographs?
I did.
And do they show two specific pieces of vegetation that you asked the Department of Agriculture agent to assist you with in identifying?
I did.
And then was that individual able to give you an identification of those landscaping items?
Yes.
I would move exhibits 55 through 57 into evidence and ask to publish to the jury.
Mr. Lychwick, any objection to 55 through 57 coming into evidence?
No,
They are received. Any objection to publication, Mr. Lychwick?
no.
And they may be used with the jury.
I'm going a little bit out of order, but starting with exhibit number 56, Specialist Nelson, what is this item that we're looking at?
It's called a catalpa pod.
And where was this pod located as it relates to the body that you found?
There were catalpa pods located inside the bag and on the body. This one I actually retrieved when I went back out and found out what I was looking for from Alex.
Okay, thank you. So this is not the one that was specifically recovered from the remains. Do I have that correct?
Correct.
But it is the same type of pod that you saw in the remains at the medical examiner's office?
That I gave to Alex, who works for the U.S. Department.
Okay.
Ms. Nelson, do you know how to spell that?
CALTAPA, I believe.
Thank you.
Now moving on to Exhibit 57. What does Exhibit 57 show?
Juniper?
And is that, this is not the exact juniper branch that was located with the remains. Is that fair to say?
No, it's another one that I went out and retrieved the same day I took the photographs.
Okay. So this individual at Department of Agriculture had identified the two pieces of vegetation you sent him as a catalpa pod and juniper. Do I have that correct?
Yes.
And then from there, you went back to the scene at 1512 East North to see if there were any juniper or catalpa pod landscaping items at that scene. Is that correct?
Correct.
And did you specifically go to the area where the remains were located?
I went on the premise, the property.
Okay. Now, in looking at exhibit number 55, tell me what I'm looking at here.
That's one of the trees that lines East North Street.
Is this tree, was it overhanging on, or was it hanging over the remains that you found?
No.
Okay, it was further down the driveway, closer to the street?
Yes.
Okay. What is this tree?
It's a catalpa tree.
Did you see these trees anywhere else on the property as it relates to the location of the remains?
No.
Okay. How close then is this tree to the remains that you found?
Can you put the map back up of
Sure.
So these would be the catalpa trees right here, and the body would have been up in here.
Okay.
Record will reflect that the witness is identified with a green line where the trees were and a green dot with where the body was found.
Thank you.
Do you want that memorialized, Attorney Thompson?
No, thank you. Okay, then. I do not have any other questions for this witness. Thank you.
Mr. Lychwick, cross-examination.
The only thing I would like to request the court to do is to provide the jury with the markings from the expert of the property, the satellite view of the property where she marked in green.
Just the one that she had up there?
Yes, please.
Sure, we can do that. So Attorney Thompson, if you can pull up Exhibit 1 again.
Yes.
And Ms. Nelson, I'll have you re-indicate on that exhibit where the catalpa trees were and where the body was found.
Okay.
Catalpa, and the body was in here.
He is like stuck on.
All right,
where
she
the body was found.
did place the same type of markings on there, so we will memorialize this as Exhibit 1B.
Whether it was like at the end of the driveway or at the bottom of the.
Mr. Lychwick, go ahead.
Otherwise, Your Honor, I have no questions for the witness.
Okay, thank you. You
Wow.
may step down. Ladies and gentlemen, why don't we take a break at this time? We've been going at it here for a little bit. We'll take about a 10-minute break for you to use the facilities and take a stretch, and we'll convene when you're ready.
All right, for the jury.
Okay, so the boat trial is not back still. So. Boat trial's not back yet. I'm looking for updates still for Carmelo Anthony, but I'm not really like real keen on very many of the updates because I don't believe any of the people. Everybody has a different I don't know. Everybody's biased, so I don't trust people's updates. I don't trust what people are saying.
Next witness is a representative of the victim. In addition to being a witness, the court is going to restrict any filming and streaming of this next witness's testimony. It can be audio, but I ask that the witness not be photographed or any visual representation of the witness because of victim confidentiality and victim privacy. However, we will be referring to her by name, and she will testify as normal. Anything else, Attorney Thompson?
No, thank you.
Mr. Lychwick, anything before we break?
My name is Lychwick, Your Honor. No, I have no questions at this time, except to add again that this is a travesty of justice on my end. I'm not receiving a fair trial.
And that is noted. We will break for 10 minutes.
Well, okay. Okay. Not receiving a fair trial. Anyway, I am looking for updates on Carmelo Anthony, but I don't trust anybody because everybody is biased on this. So I don't believe what anybody's saying. Nobody is saying anything that is accurate. So I don't trust anybody on YouTube or TikTok. I know the defense is put on their case today. I don't know. I just want to know if I'm really just waiting on the guy from I think it's Law and Crime that is there, or it might be Court TV. He is in the courtroom, and he's the only one I'm really paying attention to because he's not picking any side. He's just reporting what's happening in the courtroom. So I'm just waiting for him to come up and say what is actually happening. But I have not seen him post anything yet. So I don't know. I wish he would come out and say something, because he's been pretty unbiased as far as it's all concerned. But everybody has their opinions and thoughts on it. Honestly, it's just a terrible tragedy. I mean, it's not a tragedy. It happened. So he purposefully did it. I mean, he had a choice. He made the decision to do it or not do it. The boat situation is a tragedy. That is, he didn't decide to crash the boat and for that young lady to die. It was a tragic accident. Unlike, a DUI, where I think that is a criminal thing, because, you make the decision to get behind the wheel of a car and drive under the influence. Whereas I think in this situation, the boating crash, I mean, they were out celebrating his daughter's birthday, and they're all lifelong friends. And her parents all those parents let their kids hang out on that boat together. And with that guy and his wife. I mean, I just, can you imagine? Could you imagine? Like, it was an accident. Could you imagine like going to prison? I mean, it's a horrific, he has to live with that for the rest of his life, that he, one of his daughter's best friends died on his watch. That's horrible. I would hate that. That would be awful. Okay, we're going to. Wow. Well, they didn't even get their opening statement. This is crazy. They did not even get their opening argument. That is crazy. Oh, the defendant's not even in the courtroom. That is so crazy. Like, they didn't even finish their opening statements. How difficult is that to not finish your opening statements? That has to mess up your whole case. Well, we're back to this guy who isn't defending himself, who could possibly get a new trial if you think about it, because he could ineffective counsel. I don't know. Can you get a new trial if you represented yourself for ineffective counsel? There you go. He's not asking questions. It's like, dude, you're not asking questions. You should have been asking, what the heck? What were you thinking? You weren't thinking. Oh, we're not going to be able to see her. We're just going to be able to hear her. This is I think his sister. It's so sad. I don't understand why he did this. He must have really disliked his neighbor.
Oh,
Okay, so the track meet trial has ended for the day. The defense is rested. They're going to do closing arguments tomorrow. They ended up taking a 3-hour lunch. So the defense did not put on much of a case. And Carmelo Anthony did not testify. Adjunct means he's not getting no tenure.
What? A what? You hear it? What's a catalpa? What's a catalpa fruit? What the heck is a catalpa fruit?
They're not edible. They're just called catalpa fruit. They're just a nuisance. No question. So I've learned now what a catalpa fruit is. It is a grows as distinctive hanging bean-like capsules or cigars that can stretch from 8 to 20 inches long. They are not edible. But they're called catalpa fruit. Whatever. Nope.
I don't know what's wrong with my sound. I'm just going to try to. I'm just going to try to.
Load it back up. See if it
Have you seen each of those exhibits prior to your testimony today?
I have.
Would those be the either video or documents or screenshot from Harbor Freight that you just referenced?
Yes.
I would move exhibits 60 through 64 and 59 into evidence and ask to publish to the jury.
Mr. Lychwick, any objection to receiving those exhibits?
No,
They will be received. Any objection to publication?
no.
They will be published as well.
Detective Hallmark, I'd like to first start with the financial statement for Mr. Maldonado. How did you obtain his financial documents? I know you said that you found out he banked at Educators Credit Union, but how did you actually get this document?
We found Mr. Maldonado's debit card, and we were able to identify the numbers on the card, and we were able to submit the subpoena to Educator Credit Union.
And the subpoena prior to its submission, was it approved by a judge here in Waukesha County?
Correct.
Is that a standard practice for any warrant or subpoena that yourself or other detectives serve on a company or an individual?
Yes.
Now, when you received the financial records back from Educators Credit Union, was there a time frame that you had asked for?
Yes, there was. I don't specifically remember the large scope of the time frame that we requested, but I believe it was January 2024 through. I actually don't recall the end date that we requested it. Yeah.
Okay. In looking at Exhibit 62, is this a 3-page statement of the monthly statement for April 1st through April 30th of 2024 for Mr. Maldonado's Educators Credit Union account?
Yes.
Okay. And now when you reviewed this, if we go down to April 14th of 2024, do you see the Home Depot purchase at Delafield or at the Delafield location that you just talked about?
Yes.
Okay. Is this what I am highlighting here with my cursor? Is this the one of the purchases that he made at that Home Depot on April 14th?
Correct.
And we noticed that withdrawal POS, which you defined for us earlier as meaning he was in person. Is that fair to say?
I mean, most likely, it's
I didn't have these
POS
kind of
means
technical
point of
difficulties
sale. I mean,
until I moved
there's a
here.
potential that there's a possibility that the point of sale could be included on the
It's
credit card
internet
statement, but it doesn't
failure.
necessarily mean that the person was in person. But it routinely or commonly does refer to that, yes.
Okay. What did you learn Mr. Maldonado was doing at this Home Depot location in Delafield on April 14th?
So in review of the camera footage, we're able to determine that he rented a miter saw through the tool rental, and he also had other items that he had purchased, a paintbrush, an extension cord, there was some polyurethane and some other items.
In looking at Exhibit 60, which should be on the screen in front of you now, is this the receipt for the items separate from the miter saw that Mr. Maldonado purchased on April 14th at approximately 10:23 a.m.?
Correct.
Okay. Now, going to then Exhibit 61, what is Exhibit 61?
This would be the tool rental purchase from the Home Depot in Delafield.
And is this the
Oh man.
the rental agreement for that miter saw?
Correct.
On his last day.
Was this miter saw ever recovered from the property of 1512 East North?
It was.
Were you one of the individuals that recovered it?
I did not take possession of it, but I was there when we searched the area and we located it, yes.
Okay. Now, on this rental agreement, can you see when the miter saw was due to be returned?
It was due back on April 14th at 2:21 p.m. So it was a 4-hour rental.
And because you located it on scene at the property, is it fair to say that was not returned?
It was not.
Now, looking at Exhibit 63, what is this exhibit?
This exhibit is is a photograph of the computer at Harbor Freight showing the transaction of Mr. Maldonado's Educators Credit Union card at that location.
And we can see the transaction date on the right-hand side of Exhibit 63, and that's April 14th of 2024. Is that correct?
Yes.
Then going to Exhibit 64, what is this?
This is a receipt of a transaction that occurred at Quick Trip store number 527, which is located at, I think it's 1700 Pewaukee Road in Waukesha, Wisconsin.
After April 14th of 2024, were you able to see any other activity on Mr. Maldonado's educator's account or any other financial records that you got?
There was some activity after the 14th, yes.
And what kind of activity was that?
There was a charge for Instacart for, I don't know the exact amount, it was for like $100 some. And that we later submitted a subpoena to Instacart as well to determine what that charge was for. And we learned it was a reoccurring subscription fee.
So it was already set up. It wasn't Mr. Maldonado making a purchase through Instacart.
Correct.
I do not have any other questions for this witness. Thank you.
All right, cross-examination, Mr. Lychwick?
I have no questions either.
Detective Enos.
Actually, Judge, I did just think of one more question that I forgot to ask Detective Hallmark since he's still here.
All right, I'll allow Detective to be recalled because he's still in order. There were no cross-examination questions, but I'll allow Mr. Lychwick to ask a cross-examination question if it's
yes.
Detective, you may sit down again. Attorney Thompson.
Thank you. Detective Hallmark, I apologize. We talked about video surveillance, but I did not play it with you. I'm showing you what is marked as State's Exhibit number 59. What are we looking at here?
It'll take a moment for the screen to come up.
All right, it's up.
Thank you. What are we looking at Exhibit 59?
This is the tool rental area for the Home Depot in Delafield. The camera's pointing down towards the clerk cashier area. And if you look to the screen to the left is where Mr. Maldonado is standing with a cart with a 4x4 piece of wood. and he's got a darker color pants and a gray shirt and a blue hat. And then that's the actual entrance to the store. And if you look to the right, out that way towards the garbage can, that is the exit out towards the parking lot.
Does Mr. Maldonado, when you watch the video, end up coming closer to the counter?
Yes,
And is that when you see he is making a purchase?
correct.
Okay. What evidentiary value did this video have later on in your investigation as it relates to what Mr. Maldonado is wearing in this video?
So the shoes that Mr. Maldonado is seen wearing in this video right here match very consistently the color, the shape, the formation of how the two patterns come together, the white and the blue on the shoe matched with the shoes that were located on the individual located at 1512 East North Street.
And as far as the date and timestamp on this video, is that contained in the bottom left-hand corner in the title of this video?
Correct.
Okay. I'm going to play not the entirety of the video because it is 6.5 minutes long, but I am starting at the 0-second mark, and I will indicate the timestamp when I stop.
This is so sad. Like, why did he kill him? He says he didn't know him.
I am pausing at 1 minute and 5 seconds. Detective Hallmark, can you please circle on the screen in front of you which individual Carlos Maldonado is? Can we please capture that as Exhibit 59A?
It will be captured. Just one moment while my clerk confirms.
Did no one hear a shot? Who shot?
Now, I do not have any other questions for Detective Hallmark. Thank you.
Okay, Mr. Lychwick, do you have any cross-examination questions?
Not for the detective, but since the prosecution enjoyed re-examining this witness, I think it would only be fair that I could re-cross-examine Ms. Glenda Rose.
All right, I understand that request. I made an exception for the state here because the witness was not taken out of order. So I'm denying the request at this time to recall the other witnesses for cross-examination. All right, Detective, you may step down. Thank you. Attorney Thompson, timing-wise, do you want to call another witness at this time?
I had one on the way. I'm not sure if she is in the hallway right now. Otherwise, oh, she is now.
Let's call the witness and we'll go till, I don't want to go all the way till 5 because it's been a long day, but let's take some testimony as long as our witness is available.
Thank you. The state calls Detective Jessica Barrett.
Thank you. Detective, you may come up to the witness stand. When you get up here, please remain standing and raise your right hand to be sworn by our clerk.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may be seated. Position yourself nice and close to that microphone there, and when you are ready, start by stating your name, spelling your first and last for the record.
Detective Jessica Berendt, Jessica Berendt.
Detective Berendt, how are you employed?
I'm a detective with the City of Waukesha Police Department.
So I feel like these are the physical copies of the receipts that Detective Berendt will be testifying to. So I'll let you go through those while. Thank you. And how long have you been employed with the City of Waukesha Police Department?
Over 19 years.
And do you have a particular area or type of crime that you investigate?
I'm considered a general crimes detective, and I specialize with frauds, domestics, stalkings, death investigations, things like that.
Have you ever assisted on a death investigation?
Yes.
And do you know approximately how many times in your career you have?
I would have no idea. There's been a lot.
Okay. Now, when you are investigating a death, whether it is suspicious or a homicide or something else, is it uncommon for the police department to take kind of an all hands on deck approach?
An all hands on deck approach would be a very serious case that we work. Typically, you could have one or two people helping you out on a case at a given time. In this investigation, it was all hands on deck.
And why was it all hands on deck for this one?
Because it was clearly the manner in which we discovered the body was clearly a homicide, given the bounds and the wrap that the body was covered in. It's evident that someone did this to an individual. So we knew we were looking at a homicide. We just didn't know at that point initially who or when or how. So we wanted to quickly kind of address all different areas, and we needed a lot of resources for that. We know that based on the level of the severely decompositioned body that we were already behind in our investigation, so we needed as many resources as possible to try and catch up.
Now, when we are talking about this investigation, we're talking about the remains that were found at 1512 East North Street here in the city of Waukesha. Is that correct?
That's correct.
And were you one of the detectives that responded to the scene that night on October 30th?
Yes.
What was your role when you arrived on scene?
So I assisted Detective Stern. I was there to canvass the area for witnesses and statements and things like that. I was also there to check apartments, other apartments. I checked apartments' histories to see what kind of calls for service we had over the last 6, 8, 10 months, whatever it was that we were looking at the time. And then also just to conduct any follow-up that was needed afterwards.
You talked about looking into potential missing persons, correct?
Yes.
And are you familiar with the term premise history?
Yes.
What would that be?
So in our system that we used for our reports, and every single call for service generates an address, and that address holds a history. We call that a premise history. So I looked at the premise history for this apartment complex, and I noted that in, I believe it was May 21st of 2024, that Talisa Maldonado called in her dad, Carlos Maldonado, missing. And so we didn't know who the body was. So we were looking at different facets of the investigation. First of all, where is Carlos and is he okay? And also, who is this body? We didn't know that the two were related at the time. So I was looking at premise history and also other missing persons cases in the city of Waukesha and even outside of the city.
When you're talking about looking outside of the city, would that be within Waukesha County?
So there is a federal database for missing persons, and we were even considering looking into that before we had identification.
Did you ever expand the scope that far into the federal database, or were you able to focus in on Carlos Maldonado in your investigation?
In my investigation, I focused on Carlos.
Okay. And was law enforcement subsequently notified of an identification of the remains that were found as Carlos Maldonado?
Yes.
So now you know who this individual is or was, and now you start working on figuring out how this person died. Would that be fair to say?
Yeah.
And did there come a time in this investigation where law enforcement had identified an individual by the name of Kevin Lychwick as a suspect in the death of Carlos Maldonado?
Yes.
Okay. Now, once that information is learned by law enforcement, did you review a report or a CAD summary regarding a traffic stop conducted on Mr. Lychwick in mid-May of 2024?
I did. It was May 23rd of 2024.
And in reviewing, I'm sorry, I'll back up a little bit. Do your patrol officers in the City of Waukesha Police Department wear body cams?
Yes, they do.
And were you able to review a video of that traffic stop on Mr. Lychwick from May 20?